Item 23, my lord. My non 20.
23
Central
or
government, my lord, industrial tribunals award has been challenged. 4 awards. This is a award. Award. Award has been challenged. If it is a hearing day, my lord, I think my lord it will be better. Hearing day will be better.
You have been dismissed.
yes, yes.
When were you dismissed? When were you dismissed?
We have filed applications for recovery of money in compliance of the award passed in our favor upon by the Honorable Apex Court. But on some points that we have signed some amount, with some amount.
So you have filed an application under 33(2)(c).
33, yes.
That has been rejected.
Because they have taken voluntary DRS, my lord, our scheme was there. While matter was pending with the Supreme Court, they accepted the lump sum amount.
But that is a question which I can't decide now.
Yes.
Once it has been applied,
It's
it is only.
Honorable courts, under honorable court supervisory jurisdiction. We can only place only there are some perversity in the.
Okay, when do you want it?
The Your Honor.
9th of June?
Yes.
At a request of both the parties, the matter stands adjourned to 9th of June, on which date an attempt shall be made to dispose of the
Office building.
Item number 24.
Yeah.
The matter has been resolved, so I'd like to withdraw the matter.
Mr.
Yes, I can. Anupam Sahi.
Secretary, the Learned Counsel appearing on behalf of the petitioner submits that cause of action for which the present petition has been from us filed is no longer there, as the petitioner had been redressed. Taking into account the above, the petition therefore stands closed as infructuous. Interim orders, if any, stand taken.
What's up there?
My lord, can I pray for listing the admission column next week, my lord?
Why?
Already the date is due, my lord, not listed.
What matter?
In fact, my lord, what has happened, there is an order of the magistrate under 133 CRPC for removal of the obstruction, my lord, in the public road. Now the respondent, my lord, what has happened in the byline, his, my lord, house is at the dead end. Now in the public road, my lord, he has installed a gate. I don't get. We are beside his house, there is a passage, my lord, linking the other road.
Next week.
Obviously.
Item number 19.
19.
One line. Become infraction.
Mr. Ash Sharma, the Learned Counsel appearing on behalf of the petitioner submits that the petition has become infructuous. Taking into account the above, the instant petition therefore stands closed. Interim orders, if any, stand again.
My lord, in respect of item number 35, my affidavit in reply has not been tagged. I'm told, my lord, there is some defect to be corrected. It can be taken up. I'll do it today, my lord. It can be taken up some other day, my lord. I've informed God.
Mr. P. Patel, the Learned Counsel appearing on the interim order is there?
Yes, I.
No, we will get the interim order.
Well,
Either
then
you
we'll
wait,
wait out.
either you wait.
My
for
lord, I'll
the
try
matter.
to correct it right now. If possible, I'll get it, my lord. If possible, I'll get it, my lord.
It's a lot. She had to mention item number 40 also. So I seek permission to withdraw this letter as this letter has become infructuous. This letter has become infructuous.
Item number 40.
40.
What's your name?
Who's able?
इसको ओके कर
The
दो ना
Learned Counsel appearing on behalf of the petitioner
Yeah.
submits that the petition has become
मीटिंग इज बीइंग लाइव स्ट्रीम ओके
Taking
कर
into
दिया
account
यस
interim.
यस सर कर सकते हैं हाँ।
You appear for
यूट्यूब वगैरह
Is Supreme Court
each of the around in the four corners of the High Court.
Next, please, also. See, in respect to item 30, also, this case, Mr. Gupta is the correspondent side also. With the health commission is by Mumbai also. So, also, we have taken the consent of petitioner side also.
What is the matter about?
Now, see, in this matter, I have no knowledge.
Must be tried. Let us see when the matter reaches. We will accommodate, don't worry. Sometimes some orders are required to be passed.
Lost. There was either in motion surgeries yesterday.
I know that. We had a medical procedure 2 days back.
Lost.
I know that. So we'll take care of it. Because the thing is, whatever may be, if there is some necessity for passing an order, we'll pass an order, may not be prejudicial to the government on that day, thereby allowing the government to engage somebody else.
The lordship, item number 11 has become infectious, lordship.
Then number 11, order. Right? We'll see when the matter reaches. But that is a good chance for you to appear. Okay, with the file and appeal. Next. Don't worry. Take care. Yes. He's appearing here.
My lord.
The commissioner?
Yes, my lord. He's virtually present, my lord.
Mr. Commissioner, why
My
I
lord.
asked you to come out here is not for any other reason. The reason
My
is
lord,
when
my
we
lord.
seek for issue a notice. Whether you have paid or not, it is a different thing. I'm not on that. But the fact remains that instructions has to be provided to the standing council as you are having a standing.
My lord, my lord.
It is very unfortunate that the notice was issued in the month of December. Until now, till the 4th of May, there was no instructions provided. I would have understood that if your office was further down somewhere in July, the standing council could not obtain the instruction. That is a different aspect, but it is just a stone throw distance from here.
My lord, unconditional apology, my lord. It was basically we were expecting the government funds to have arrived by that time since we had received the financial sanction. But my lord, unfortunately, we could not receive any financial ceiling by the end of the year, my
No,
lord.
no, I'm not on the. That is why, Mr.
I tender
Commissioner, I'm not
unconditional
on the
apology, my
question
lord.
that whether you have received ceiling, you have the money, you don't have the money. Those are things which will be taken up. But
My
that
lord.
is something which needs to have been intimated to your standing council.
Yes,
If
my
you
lord.
don't inform your standing council, the problem what happens is this court cannot proceed with the matter. If you
Yes, my
inform,
lord.
we'll pass some orders to that effect. What is
Yes, my lord.
required to be done.
Yes, my
So
lord.
therefore, my only earnest request to you is whenever a matter notices is sent, kindly provide the instructions. That is otherwise than not. That is the reason why I've asked you to come.
Noted, my lord,
appear
and
today,
I
yeah. So
noted, my
that
lord.
you see, after all, when a notice is being issued, this court issues a notice to you, you have to provide
Yes,
the
my lord.
instructions to your standing counsel as you have a set of standing counsel.
Yes,
That
my
is the
lord.
only reason.
Yes, my lord. I tender unconditional apology, my lord. My lord, it was not intentional. Because of some communication error, it must have happened. But however, my lord, I tender unconditional apology, my lord.
No,
It
it's
will
okay.
not be repeated.
I understand, Mr. Commissioner. You next time onwards, kindly ensure to take note of your
Yes, my
higher
lord.
office and ensure that
Yes,
whenever
my
a
lord.
notice is being issued, kindly intimate your standing counsel. Because
Yes,
it
my
doesn't
lord.
looks nice. The standing counsel appearing before this court says that on twice he comes up and says that no instructions are being provided. So
Yes,
it
my lord.
doesn't looks nice on the GMC. You are
Noted,
to
my
take
lord.
you are only to inform him what is the status of the affair. You
Noted,
have
my lord.
anything, kindly inform him. Okay.
Noted, my lord. Noted,
Yeah.
my lord.
Thank
Noted, my
you.
lord.
So in the meantime, I will see my instruction, my lord. There are subsequent development.
Okay. Then we dispense your appearance, Mr. Commissioner.
Highly obliged, my lord.
Yes. What is that?
Lord, I will see my instruction. The subsequent development is that, Honor. There is a meeting and thereafter 50% of the amount has already been extra.
Anyway, you put it on affidavit.
Put it on.
Mr. So-and-so, the Commissioner GMC is present before this court pursuant to an order passed by this court on 4/5/2026. Present before this court, the video conference in link pursuant to the order passed by this court on 4/5/2026. Mr. Esbora, the learned standing counsel of the GMC further informs this court that he has already received the instructions and he would like to file an affidavit in that regard. List this matter again on 10th of June 2026. In the meantime, the affidavit be filed on or before 8th of June 2026. The personal appearance of so-and-so, the Commissioner GMC is dispensed with. Okay, Mr. Commissioner.
My lord, oblige, my lord.
Will be allowed to withdraw this petition.
Ms. Again, the learned CBC submits
Disconnect.
that she has received the
Is it
written
so hard?
instructions for withdrawal of the instant petition.
Hmm?
Accordingly, the petition stands closed on withdrawal.
Must have that.
Mr. Hawk,
Tender was floated, my lord, by the Mandi Ansari Panchayat.
you are now again against the PNRD also. Ah, I heard that you are only sharpening your weapons against the PWD. Now you are against PNRD. Also. Just tell me what has happened.
My lord, here, my lord, the tender was floated, my lord, on 23/5/2025, my lord, for the year on, for the period of
In 36/2026.
2026.
Then
Which had participated, my lord, against the market, my lord, under the Monte Ansari, namely, Sherrod, Ancholi, Guru, brother, my lord. Thereafter, my lord, they have prepared a, my lord, comparative list also, my lord, statement, my lord. What is the petitioner's name has been shown at,
where is your name?
my lord, page 30, my lord.
Amount deposited by the tender so and so.
Yeah, my lord, petitioner's name is at page 12 or 1, my lord.
There is another bidder who has quoted the same amount.
Thereafter, my lord,
Many persons have quoted the same amount.
yes, my lord,
Then what happened?
3%. Thereafter, my lord, due to non-settling of the same, my lord, petitioner has prepared an extension, my lord, before the additional chief secretary, PNRD, my lord. In pursuant to that, my lord, page 35 will loss, fine, my lord.
What remains in this petition? Period is ending on 36.
My lord, at least, my lord, what happened, my lord, against this particular market, my lord. There is a one, my lord, private cattle market, my lord. On the interest of the, my lord, private cattle market, this government market is not being settled. Once it is settled, my lord,
That's not very well. But the fact that this has happened long time back. See, the tender was issued on 23/5/2025.
yes, my lord.
The period was from 1/7/2025 to 36/2025. We are in the month of May.
My lord.
I can't
Hardly
direct,
1.5
today I can't direct them to settle it. I have to issue a notice to them. Once I issue a notice, then they will take a call as to what action is to be taken. Here, this person has also signed, what is the name? But the Secretary Panchayat and Rural Development has also directed the Chief Executive Borpeta Jila.
Yes, my lord.
Do it, but then also he has not
Yeah,
done it.
my lord.
And most probably he must have not have done it because this document was issued on 10/3.
Yes, my lord.
15/3, we have the model code of conduct. It ended on 4th of May. We are in, they are going to be,
My lord, here, what happened, my lord,
or the chief executive officer doesn't listen to your commissioner and secretary.
Because of, I have telephonically instructed my lord that because of the model code of conduct, they could not, and some issues of some government value also fixing of government value. In fact, after that, my lord, another 2 times retender was done, my lord. But because of adequate value, they have not settled, my lord. As per the.
So you don't need the money.
No, my lord, the department
the
is
question
directly.
like, the question is, you are saying that for inadequate value, you are not
The
settling.
department directly running the market, my lord.
The department is running it.
Yes.
Department is running it. You are saying because of the cattle market, that market is not functioning.
Usually collection.
Previous year.
Can I hand it over to?
Different from the validity of the. But didn't you put but the fact remains that did you not put the minimum value of the year? Must have put it.
Earlier there, my lord, but because of some maybe commissioners, my lord, later it was enhanced. That is why they requested to reduce, my lord.
Understood, but in the tender, you must have put something.
Yes, there. In tender, it's lower value is there.
We are concerned in which market?
Sour Vita.
Huh?
That is a
Sotrakarna. Which tender we are concerned?
this 15 page serial number 4 by.
Sour Vita, we are answering.
So it is 837, 38.
In this tender, 838 is there.
So then,
Thereafter, 2 times retender was there. That time. And in fact, from this.
no,
Yes, my
this was the last tender. On 23/5/2025 is the last.
Thereafter, my lord, Lordship, may kindly have the my. Letter, my lord. Again, 2 times it was retendered.
This is against.
Yes, that is why I'm fairly submitting, my lord.
So the question is, you have fixed at 8:38. The minimum bid, you have fixed at
yes.
8:38. Now kindly see, for 2022-23, the amount was 9,01,000. 23-24 is 1,12,000. 24-25 is 9,600. Now, in this case, it is, you have fixed at 8,38,000. And three bidders have quoted 9,22,000. And you are not giving, what is the justification?
Yes, my lord.
You
I
are
was
not
also
giving,
thinking the
meaning
same.
thereby you are trying to favor the private cattle market. This is what is being mentioned out here.
Now, my
And
lord,
what Mr. Hawk says, is absolutely correct.
maybe something is there, my lord. I have to fairly submit, my lord. But may I, at this stage, my lord, may I suggest one thing? My lord?
That means you are not running it also. From the apparent, what does it say? That in view of the private capital market which is functioning nearby, you are not getting anybody because you don't provide proper platforms and as such, they are selling you, they are giving better opportunity, so nobody is doing it.
My lord, in that
This
case,
is what is being
lordship
mentioned.
may fix it, short table, I'll place written instruction from them for their justification, because I don't want to.
Yeah, your officers something wrong. They don't want to recognize the private capital market. And thereby losing the revenue, they want to lose the revenue, but to better, and let the government do. And let the private people do.
Or may I suggest one thing, my lord? Cure that, my lord. My lord, now, my lord, we are on May, my lord, and for tender, 45 days notice is required. And for 1st July, my lord, this is the time, my lord, for, we have to issue the tender, my. So lordship may direct, my lord, to issue fresh tender for the next year at least, my lord. So that, and they have to comply with it.
Why should they direct? Otherwise, they have to do it.
Yes, my lord.
So why should they direct?
For that direction, we.
After holding a tender, you have not done it. So therefore, we are to catch hold of the chief executive officer of the Kolkata Jilla Parishad as to why he has not acted upon the direction of the commission secretary.
Yes, that instruction, written
That
instruction.
appears to be more proper. And as to why this amount which the loss, they would have paid 9,22,000. So this amount should be recovered from him, from selling the assets.
My lord, in similar one, another case, my lord,
This is a good order.
the government was directed to conduct inquiry, my lord, because of the misconduct of the
This is
district.
a pure case of misconduct.
Lordship may disposal of directly the government, my lord.
Case of disposal. We are to ask the secretary why this has not been done and to conduct an inquiry as to because of the actions of the chief executive officer, the government has lost the needle.
Yes.
And thereby, and Mr. Hawk, then you may have to withdraw later on the petition. But the chief executive officer would put pressure on. No. Okay. Issue notice returnable on 10th of June 2026. You won't get it, Mr. House. You may not get it. But the question is, this is a question of propriety. Mr. S. Dutta accepts notice on behalf of the respondent numbers 1, 2, 3, and 5. Mr. M. Sekia accepts notice on behalf of the respondent number 4. Extra copies of the petition be furnished to the respective councils by today. A notice inviting tender was issued by the Chief Executive Officer of Kolkata Jilla Parishad. That is the respondent number 3, dated 23/5/2025 for settlement of various markets. The market in the present proceeding is the South Vita, SAWRARVITA, জনপ্রিয় আঞ্চলিক গরুর বজার। The government estimated value of the said market was put at rupees 8,38,317. The report reveals that in pursuance to the said notice inviting tender, at this stage, it pertaining to mention that the period for which the settlement was to be made was from 1/7/2005 to 2025 to 36/2026. In pursuance to the said notice inviting tender, as many as bidders, na? 6 bidders participated. Six or three? One,
sorry.
two, three bidders. Four bidders. Three bidders. Three bidders participated.
Yes.
Others are guarantor.
Yes, yes, yes.
Three bidders participated. And quoted an amount, and all quoted an amount of 9,22,148.70. And two bidders quoted an amount of rupees 9,22,148.70 paisa. Whereas one bidder quoted 9,22,148, isn't it? Or have you missed out the 70 paisa? Oh, all quoted. Mr. Oh, very difficult to trust from your translated. All the three bidders quoted an amount of rupees 9,22,148.70 paisa. Thereupon, there was no settlement made. The contract. What is that provision when it is common, there is a lottery or something, but
Financial.
there was no exercise carried out. In terms of
Tender clause in itself there.
will be in the constitution rule, in the financial rule.
Rule 47.
Rule.
Rule 47 is the, settlement line.
40. 40.
47 is the main rule, sub rule is the.
There is a provision I have. seen.
Tender itself.
Huh?
In the tender itself.
No, there is also a rule. Yeah, 13A. Although the three bidders have quoted, eligible bidders have quoted the same bid amount. But no steps was taken in terms of clause 13 cap small a of the notice inviting tender dated 23/5/2025. Under such circumstances, the petitioner submitted a representation on 16th of October 2025 to the Additional Chief Secretary, Government of Assam, PNRD Department, requesting him to take some action for settlement. The record further reveals that on basing upon the said that the Secretary to the Government of Assam, Panchayat and Rural Development Department have issued a communication to the Chief Executive Officer, Borbeta Jilla Parishad on 10/3/2026 to collect the 100% of the settlement amount for the remaining period of the Panchayat year 2025-26 from the respective bidder at the time of settlement, a time of enter to that the communication dated 10/3/2026 directed the Chief Executive Officer, Borpeta Jilla Parishad, to take effective steps, to take immediate steps for settlement of the market with the bidder who qualifies all norms of the model NIT. In spite of that, no action was taken. And it is under such circumstances the petitioner has approached this court by filing the petition. Today, when the matter is being taken up, Mr. S. Dr. the standing counsel of the respondent numbers 1, 2, 3, and 5 submitted. And standing counsel of the PNRD department submitted that on 4/8/2025, an instruction, a communication was issued by the Chief Executive Officer of the Borpeta Jilla Parishad to the Commissioner of Panchayat and Rural Development Department, wherein it was mentioned that in respect to the market the common estimated value is required to be reduced. In as much as for the years 2022-23, 2023-24, and 2024-25, the amount deposited by the lessee was rupees 9,01,130, 1,12,900, and 9,600 respectively. It is also mentioned by Mr. S. Dr. the learned senior counsel, learned standing counsel, that on account of the model code of conduct, which was operational till 4th of May 2026, no action could be taken in pursuance to the communication dated 10/3/2026. Be that as it may, a question duly arises, more particularly from a very perusal of the communication dated 4/8/2025 issued by the Chief Executive Officer, the Borpeta Jilla Parishad, as to why the settlement was not carried out at the rate of rupees 9,22,148.70 in favor of any of the three bidders, which was higher than the government estimated amount in respect to the market. As well as, in addition to that, questions arises as to whether on account of the private market, which was holding, which is situated at 1-1.5 kilometers from the market in question, the settlement was not carried out. It is very pertinent also to observe that non-settling of the amount, non-settling the market, leads to loss of the government exchequer. So, under such circumstances, this court therefore directs the Secretary, PNRD Department, to make necessary inquiries in the meantime and place a report as to why, under what circumstances, the settlement of the market in question was not carried out. Despite the fact that amount so quoted, there were three eligible bidders who have quoted more than the government estimated price. Needless to mention that it shall not be a bar on the part of the respondent authorities to take effective steps for settlement for the remaining period. It's advised. You get it? The instructions so placed before the court by Mr. Elgappa is kept on record and marked the letter. Hello. Some Sark is on, what does it have to do?
Lordship, we have challenged the award passed by the Ladakh Labour Court, Dibrugarh, upholding the dismissal of one of its members. Dismissed by the management. Award is at page 58, Lordship. In the award, Lordship, the
Why you are challenging now? After 2 years,
some delay is there, Lordship.
why should we entertain the petition? You
What
took,
when-
you applied for the certified copy on 8/11/2024.
The work
We are
when-
in 2026. Why should we entertain this?
Lordship, work when, Lordship.
What is the direction given?
The upholding the dismissal order, Lordship.
Huh?
This dismissal order was up.
So? And then what happened?
What happened, Lordship,
After upholding, what do we do?
Lordship,
In the light of the discussions above, we need that the preliminary issue that if the domestic inquiry in respect of Via was conducted in court, as well as the system, and for the will be able.
relying upon the domestic inquiry, Lordship.
Huh?
Only relying upon the domestic inquiry, Lordship. Preliminary issue is same, Lordship.
Then,
There is some publicity in the inquiry, Lordship. What happened? If your Lordship produces the
what
Focus,
is
Lordship.
your case? I would have allowed your petition on the first day itself, not it, on the question of domestic inquiry. The domestic inquiry, is right or wrong, that's a different perspective of matter, but the court should have looked into the issue of proportionality of the punishment,
Lordship.
which is as per the judgment in the case of
Milestone.
no, ML Singh. I think so. That is the case. Wherein it says once the domestic inquiry is being looked into, if it is held to be fair,
Okay.
then the next question for the court is has to look into the question of proportionality, because domestic inquiry is for proving the misconduct. Now, the second question is as regards the punishment.
Lordship.
So there the court has to come to an opinion as to whether the punishment was justified.
Fair.
Isn't? So, what to do?
I can notice.
But it's very late.
Notice my workman, Lordship.
Why?
1.5 hours late, Lordship. Notice my Lordship.
What were you doing all this while? Very difficult.
Union is before his Lordship. Now the union is before his Lordship, protecting his
Earlier also the union was there. It is because of the fault of the union.
Lordship. Notice made,
A person has been suffering on account of the fault of the union.
No, Lordship.
What is wrong with the union?
Notice made, Lordship.
Notice?
Because some perversities are there.
What is the purpose?
Lordship, what happened if your Lordship, peruse page 18, Lordship, the Shokas, Lordship. Shokas, Lordship, only one line of Shokas. And the management went on developing the story in the domestic inquiry. And our stand before the management and the inquiry officer was that the workman was a store clerk, Lordship. Like the workman before this honorable court was a store clerk. So he stated that physical stock was not handed over to him at the time of taking over the charge. Now management is saying that there are some differences in the stock. That was the only charge. And subsequently, they developed this.
Should notice making it returnable on 3rd of August 2026. MPK, the council, the government council accepts notice on behalf of the respondent number 1. Extra copy of the information be furnished by tomorrow. As regards the respondent number 2, steps be taken by way of speed post within 3 days. In addition to that, The petitioner is also directed to effect service upon the respondent number 2 by way of dusty to the registry of this court and file an affidavit of service on or before the next date. The petitioner hearing have assigned the award dated 2/8/2024, passed in reference case number 3/2021, whereby the reference was decided by upholding the domestic inquiry of the domestic inquiry. The learned counsel appearing on behalf of the petitioner submit that the interim awards not only suffers from perversity in respect to the decision pertaining to upholding the domestic inquiry, but also the interim order cannot be sustained in law, taking into account that there is no reasons assigned on and there is no adjudication carried out as regards the proportionality of the punishment, which is the requirement as per the separate principles of law. Taking into account the above, this court in that view of the matter, the records of so and so are called for. The registries is directed to ensure that the records are placed before this court on the next day. And if necessary, to ensure that the records are placed before the court on the next day. Taking into account that the instant proceedings pertains to a dismissal of the workman, and there is a requirement that these industrial disputes have to be brought to an end at an early date as per the separate principles of law. An attempt shall be made to dispose of the petition on the next. You serve it. What is this?
From 1997 onwards. Partner have been listed as regular product in the product from 1994. I have also attached from
What?
water melon passed in similar category. I have
Huh?
water passed by this honorable board. Page number 36, my lord. Similar question.
Page?
Yes, 36, my lord.
This is not my case.
Not yet.
That is my order. Get an order of which I have passed. Look, hey, be very responsible. Yes. What is your case? Don't cut, sir. Stone crusher where? In forest?
Forest.
Forest use allows stone crusher.
Forest, and forest, not even in.
Then he wanted to inside the forest.
No.
So you applied for some
Yes,
permission.
applied on 31/8/2024.
T8, 31E.
Yes, 2024.
And then
Lordship, as per the guidelines for installation of stone paper, forest department and profit, within 15 days they are to field visit. So, and thereafter they are to go. It will go to the permit level committee. Then after approval of the permit level committee, Lordship, the ultimately on approval of the this conservator of forest, the DFO could issue the permit. That is the procedure. So I have
you-
applied on
you have-
31/8, Lordship.
you have reached to which level?
Lordship, this even Lordship, the so far
because the permit of internal documents are not provided to us. It was the permission was after necessary verification, the approval was given to the chief conservator of forest. That there is no any impediment. We have already filed the pollution. Pollution is the main load. Pollution certificate, NOC, everything.
So your file now is with the chief.
With the chief conservator of forest, PCCF. Principal
And
chief
from
conservator
there,
of
the
forest.
DF, once he gives the sanction, then you'll get the license by
DF
the,
got-
by the DF.
So we have all as because our last approval, internal the departmental approval was given on 24 to 26.
Issue
And then on
notice.
13/3/26 we have filed representation of it.
Issue
today?
notice making it returnable on when
After 2 weeks, I will get the
instructions. Serious, huh? You have to get it. Issue notice making it returnable on 29th of May 2026. Mr. Ibotago, the Standing Counsel of the Forest Department, accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the petition will be furnished during the course of the day. The case of the petitioner herein is the petitioner wants to set up a stone crusher unit and accordingly has submitted an application on 31/8/2024 along with all necessary documents. It is therefore the case of the petitioner that the due verifications have also been conducted and the pollution and the certificate from the Pollution Control Board have also been submitted. In spite of that, the respondent authorities have not taken any steps for issuance of the license, thereby affecting the rights of the petitioner to run, to proceed with to operationalize the stone crusher unit. The learned counsel appearing on behalf of the Forest Department shall apprise this court on the next day by way of instructions as to why the petitioner's application have not yet been processed. This court shall consider about filing of the affidavit on the next day, subject to the upon the production of the instructions by the Standing Counsel of the Forest Department. Mohakali Estates, date of birth. What is this?
So read against the order of the industrial terminal Dibrugarh. Order
What?
is on page.
So against? What is this?
Lordship, the order suffers from perversity, Lordship, regarding the terms of the reference law.
What are you challenging?
Lordship, the
Tribune order
challenge
dated 24/2006. Let us see.
26. Page number 278.
Yeah, what is this? Usto Chandra Swayam had a case for. What are you challenging?
Lordship, the last part, Lordship, page 281, if Lordship will read. From Lordship, page 280, last part. However, since
With the proper authenticated regarding the compliance with public charge taking. It shall be done on the right road. Yes.
Yes, Lordship, the terms of reference is regarding the terms of service. The change in the circumstances of the service conditions, Lordship. Now, Lordship, what happened, Lordship, on 2022, Lordship, the Honorable High Court, Lordship, they filed a writ petition challenging the jurisdiction of the Industrial Tribunal in the reference case number 2 of 21, Lordship, in which regard this order was passed, Lordship. Lordship, in this writ petition, Lordship, the learned court, High Court, Lordship, passed an order in page 24, if Lordship may look, Lordship, paragraph 9. 24, Lordship. The operative portion, I'm just reading for your.
The different states.
Lordship.
What is this?
Lordship, this was the order in terms of the writ petition filed by Mahakali regarding the terms of reference, Lordship. So, Lordship, in the paragraph 9 is literally the concept of framing preliminary issue is not alien to the aspect of
But there is a
dispensation.
reference me.
Lordship.
So what was challenged out here is the reference.
No, Lordship. The thing is this, Lordship, in this order, Lordship, the learned High Court, Lordship, directed that a reference to be adjudicated in terms of agreement dated 6/10/1969, Lord. In fact, Lordship, there are two tea gardens, Adabari and Mahakali, Lordship. They belong to the same group, Lakshmi Group, Lordship. So two writ petitions were filed, and both of them were combined because the terms were basically the same. Lordship, however, the agreement dated 6/10/1969. This was present only in the case of Adabari. It was not present in case of Mahakali, Lordship. So, Lordship, what happened after this, the case was remanded back, Lordship. The tribunal observed, Lordship, in page 26, Lordship.
So what was the direction passed here?
The direction passed, that's what I was reading,
The
Lordship.
matter accordingly stands remanded to the learned at this stage, this court has informed that present the concerned tribunal is not a two-way matter. Parties may appear before the immediately be functioning. Take change of the matter. What was the direction?
Direction was, Lordship, to adjudicate the dispute in terms of the agreement dated 6/10/1969, Lordship, in paragraph 9.
So where is your reference?
Lordship, my reference,
Where is your reference notification?
Lordship, reference notification, page 26, Lordship.
Page?
26, Lord.
Whether the management of Mahakali is justified to notify the notice under 12, changing the existing condition is sufficient. Pensionary benefit enjoyed by the retired staff. Okay, so this is a dispute.
This is the dispute, Lordship.
Then,
Then, Lordship, regarding this, Lordship, if Lordship may have a look at page 267, Lordship. Lordship, this is the order passed on 8/9/25, Lordship. Herein, Lordship, the tribunal has stated that parties here to submit that Moran Tico Limited was never predecessor to the interest of the present management for Mahakali Tea Estate, and the agreement dated 6/10/1969 mentioned in the paragraph 9 of the order dated 19/9/22 by the Honorable Gauhati High Court by WBC number 5586 of 21 was never entered into by any of the predecessors in the interest of the present employer company, and therefore mention of the said agreement in paragraph number 9 mentioned above seems to be a result of a clerical error. This tribunal has also not been able to find a reference to the said agreement in any of the pleadings by the parties in the notice and in a notification of reference in this. Lordship, then the Lordship, the tribunal sought guidance or clarification from the Honorable Gauhati High Court, Lordship.
Then what happened?
Then what happened, Lordship? They had sent a notice, letter to the Registrar Judicial of the Gauhati High Court, Lordship. However, they received a reply on page number 269, Lordship, by order 16/10/25.
Where is it?
Lordship, page 269, Lord.
Eh?
269.
What is 260?
Yes, Lord.
No, the matter was fixed for further response from the Honorable High Court, and the response had been received by the annual tribunal on 3rd of October. Let the same be indication. Where is that document?
Lordship, that, we do not have that matter, but as per my instruction, Lordship, in that letter, it was stated that the Honorable Registrar Judicial cannot give a clarification in this matter. So the management, Lordship, they were asked to seek clarification. Then lordship, because of the miscommunication maybe lordship, petitions could not be filed before the Honorable High Court. Lordship, however, we have filed a petition on 24/2026, Lordship. We have already filed that. Lordship, then, on 23/3/2026, Lordship,
What happened to that application we,
Lordship,
which was filed by the High Court?
no, Lordship, it's
Pending.
yes, it's pending, Lordship. It's pending, it's Lordship, and 24, it's still pending, Lordship. It's an IA of the disposed case, Lordship. Since the main case was disposed, it's taking a bit time, Lord.
But this is an seeking for clarification.
Yes, Lord.
Then that court has to take it.
Yes, Lordship, that court has to take it.
Why you're not mentioning it?
Lordship.
Why you're not mentioning it before that court?
Lordship, there are some objections, Lordship. Original objections have been complied with, Lordship. We'll mention, Lordship.
Oh, you have no urgency.
No, Lordship, there is an urgency. Lordship, please have a look at this order, Lordship, on 18, Lordship.
This order was- Now, what is the order passed here?
The order passed here is, Lordship,
In view of the way directed to Amivan Suranto who has signed and verified that each shall be a person to explain the what this petition by on behalf of the management is not in line with the direction given in paragraph 4 of the petition. The so and so advocate representing the activity based on instruction given by the. So what is happening? What is the problem you are facing now?
no, the problem we are facing is, Lordship, on 24/2026, the company representative appeared personally before the land.
Okay, then what happened?
Then
What
lordship-
admit that he has been, he
And
has
he-
advised the company that the contents of the petition would suffice for the interest of the company in the legal process. This is the bizarre since the tribunal only remembers that after response to the order that he has received from here to tribunal and directly to some also the matter from the proper authority which unequivocally meant with the Honorable Gauhati High Court by his commission clarification so that the matter could be proceeded. It was still as you of the order it is eventually each of the direction given there is as the report was discussed. No steps was taken for something to take this. When did you file that application?
Lordship, on 24, Lordship.
With the proper and authenticated documents regarding compliance with security. What is the section 77 and 78?
Second, it's regarding charge, Lord.
Why is it necessary?
Why is it necessary? That's the reason is not been given, Lordship. Why is it necessary? The adjudication is regarding the terms of service, Lord. The charge of assets is not necessary in this case, Lord.
Certified copy of the hearing.
What is the necessity for charge, Lord? Section 77 is duty to register charges, Lordship. Section 78 is application for reparation of charges. Section 85 is, Lordship, company's register of charges. Lordship. Now, what relevance these documents have in this case, Lord? It's a simple industrial dispute, Lordship, regarding terms of service, Lord.
When you file application, when you get to file,
Lordship,
when did you file the application?
Lordship, on 24, Lordship.
24.
It's pending is IA 1510 of 26, Lord.
It has been registered.
Registered recently, Lordship, because of some objections regarding the conditions of the of the return statement of the workman, Lordship. There were some inclarities, Lordship. We have to give fresh type copies of everything, Lord. So it's been registered now, Lordship, on 1510 of 2026, Lordship. It will be coming up, Lord.
1510.
10 of 26. IA 1510 of 26, Lord.
Now what do you want here?
Lordship, the main plea is Lordship, the order is at 24, it may be stayed, Lordship.
Why?
Because Lordship, the, I mean, the order is perverse in the law, Lordship, because there is no reason of why section 77, 78 and 85 of Companies Act is involved in this case. And Lordship, moreover, a fine of 50,000, Lordship. It's clearly beyond the terms of reference, Lord. Lordship, this
You paid a 50,000 here. Give it to the Gauhati High Court bar. First of all, there appears to be some laxity on your part,
Lordship,
taking into account that why, when the court has been asking you to get a clarification from the court, why haven't you done it?
no, Lordship, here was some structural changes in the legal team, Lordship. Here are 150
We are
pending
not
cases, Lord.
concerned that structural changes in the legal team, whatever may be, there was a direction passed by the tribunal. Why haven't you taken action on the basis?
Yes, Lordship, that
So we say it's subject to depositing 50,000. So there has to be some lapses.
Lordship, lapses may be
50,000 deposits. There were
my humble request, Lordship, please stay of it to deposit of 50,000.
no, because of you have the direction was passed to you on such a long earlier period. There's a direction.
16 and 25, Lordship.
You want this order to be stayed, the proceedings not to be stayed, because are you not stalling the proceedings?
Lordship, no, Lordship.
Yes, you have been asked to obtain the instruction.
Lordship, that miscommunication on the part of the council and the
Then
company
in
was
that
there.
regard, we do one thing, we dispose it of with this petition, saying that, okay, they do not insist, and the court shall let the court proceed as it is. Your
No,
defense is tough. Okay,
No,
no
Lordship,
problem, no. You are saying that 16,969 is not a document. The court, the learned labor court say that this is a particular document which has been mentioned in this order. So first he tries his luck to getting it from the registered judicial as to whether he can provide any clarification. Registered judicial on 3rd of October says that look here, we are not in a position to provide. Now, under such circumstances, he has asked you to kindly get a clarification if you want on the to raise that issue. That is your preferred raising of that issue. Now you have not done it. So therefore, we dispose it of, saying that let the court proceed as if that as per the order passed by the court. That's over. Allowed. Your repetition is allowed.
Lordship, please, Lordship, it's a.
No, your repetition, I'm allowing your repetition, setting aside that direction. You want that. Because I have to also understand that the labor court matters are to be taken with urgency.
Lordship, this part, Lordship, this 50,000 and Lordship submission of documents regarding the.
No, I'm therefore setting aside to that effect and let the court proceed on the basis without insisting on that these directions. Let the court proceed. Your purpose is some. Later on, you cannot raise that 69. It will be on the basis of the understanding of this all.
But that's the Lordship, the 151 is.
I'm
pending
not concerned.
clarification.
I'm not concerned. I also know why you are doing it. You want to delay it. These are persons as regards the pension benefits you are taking away. You are taking away these pensions, whether they are entitled or not. At the stage when these people have retired, you have now taken up the stand that we are removing these benefits which are there. That is an industrial dispute. Now that is, if there is a delay, what will happen to those persons who have retired? So we allow your petition with a cost of 50,000. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. M. Sethi appears on behalf of the respondent number 1 and 2. Taking the order which this court proposes to pass, this court dispenses with the service upon the respondent number 3. The petitioner herein have essayed the order dated 24/2026 passed by the learned labor presiding officer, Industrial Tribunal, Dibrugarh, in reference case number 02/2021. It is noticed that by the said order, that a perusal of the said order reveals that the learned Industrial Tribunal was perturbed by the actions on the part of the petitioner in delaying the reference proceedings on one hand, and on the other hand, having not filed any application. The said aspect prima facie appears to be correct, taking into account that the order was passed on 24/2026, and the application seeking clarification was filed on 24/4/2026 as submitted by the learned counsel for the petitioner. Be that as it may, this court finds it very pertinent to take note of the brief facts which led to the filing of the instrument petition. An industrial dispute arose in Mahakali Estate on account of changing the existing service conditions and discontinuance of pensionary benefits enjoyed by the retired staff employees with effect from 15/9/2020. Resultantly, a notification was issued on 8/3/2021 by the government of Assam, notifying in terms with Section 10 of the Industrial Disputes Act 1947 various terms of reference which were mentioned in the schedule to the notification dated 8/3/2021. The terms of reference were, as mentioned in the schedule to the notification dated 8/3/2021, being relevant, are reproduced hereinunder. It further appears that the petitioner T-State had filed a writ petition being WPC number 5586/2021. Challenging an order dated 6/9/2021 passed by the learned Industrial Tribunal in reference case number 2/2021. Where is that 6/9? 6/9/21, where is that order?
That order has not been annexed. That order has not been annexed.
It was the case of the Pustak. It is also relevant to take note of that the learned coordinate bench of this court disposed of the said writ petition filed by the petitioner, along with another writ petition being WPC number 5574/2021. At this stage, it is pertinent to, it is relevant to observe that WPC number 5574/2021
was challenged in order dated 6/9, a similar order dated 6/9/2021 passed in reference case number 1/2021 by the Learned Industrial Tribunal, Dibrugarh. The records further reveal that though there was a challenge to the order dated 6/9/2021, the petitioners have given up the claim. They've given up the challenge and limited its prayer before the learned coordinate bench with thereby seeking a direction upon the Learned Industrial Tribunal to decide on the question of the binding effect of the agreement vis-a-vis Section 18 of the Industrial Disputes Act 1947. The learned coordinate bench of this court, by an order dated 19/9/2022, disposed of the said writ petition, both the writ petitions being WPC number 5574/2021 and WPC number 5586/2021 by a common order, thereby directing the Learned Industrial Tribunal to decide on the question of applicability of Section 18 of the Act of 1947 vis-a-vis the binding effect of the agreement dated 6/10/1969. The said order was passed in accordance with the said directions passed by the learned coordinate bench of this court in the judgment and order dated 19/9/2022 in WPC number 5586/2021 and WPC number 557/2021, the Learned Industrial Tribunal took steps for deciding the issue of applicability of Section 18 of the Act of 1947 to the agreement dated 6/10/1969. At that stage, an application was filed almost after almost 3 years thereafter by the petitioner, stating inter alia that there was no agreement dated 6/10/1969 between the petitioner T state and the respondent number 3.
So it was observed by the learned tribunal itself, right?
That is your stand. And as such, there appeared to be a clerical error in the order dated 19/9/2022 passed by the learned coordinate bench of this court in WPC number 5586/2021. When the said aspect was brought to the attention of the Learned Industrial Tribunal, the Learned Industrial Tribunal in the right earnest passed an order on 8/9/2025 seeking guidance from the Registered Judicial Guwahati High Court as to whether the agreement dated 6/10/1969 mentioned in para 9 of the order dated 19/9/2022 in WPC number 5586/2021 is a result of some clerical error, or if any material was placed by the parties before this court, showing that the said agreement was entered into by the predecessor of the interest of the management of Mahakali Tea State. It appears that on 3/10/2025, the Registered Judicial of the Gauhati High Court duly intimated the learned presiding officer of the Industrial Tribunal that it would not be competent on the part of the Registered Judicial of the Gauhati High Court to give such a clarification. On 16/10/2025, the petition, the learned Industrial Tribunal thereupon passed an order asking the petitioner to seek necessary clarification from the proper authorities to clear the confusion. The records reveal that the proceedings was that the said reference proceedings was thereupon fixed on 25/11/2025, 23/2/2026, 23/3/2026. Fixed on 25/11/2025, 8/12/2025, 7/1/2026, 23/2/2026, wherein no steps were taken by the respondent authorities, by the petitioner, to seek the clarification from this court. It is also very pertinent to take note of that on account of the clarification not being provided, the reference proceedings was also stalled. It may not be out of place to observe that it is the legislative mandate that the reference proceedings is required to be disposed of as early as possible and preferably within a period of 6 months. However, on account of the delay, the said reference proceedings, which was initiated sometime in the year 2021 on the basis of a notification, have already been delayed by almost 5 years. It is under such circumstances when on 24/2026 the matter was taken up, there was no clarification produced from this court, neither any clarification produced before this court. Rather, an affidavit was filed, a petition was filed.
Before the company representative, he appeared personally before the learned president.
Whether the company representative who was present pursuant to the order dated 23/3/2026 stated that steps would be taken for seeking necessary clarification in the matter from the Gauhati High Court. First, the record reveals that it is being submitted by the learned counsel appearing on behalf of the petitioner, that it was only pursuant to the order dated 24/2026, clarification was sought for. An application has been filed and it has been recently registered and numbered as IA civil number
1510.
1510/2026. Be that as it may, the Learned Industrial Tribunal by the order dated 24/2025, 26.
Prime Minister Lordship, the I was filed before
Directed.
24, on 24 itself. On 24 itself it was filed.
204 or to
24, Lord. On 24 itself it was filed.
24.
Yes, 20.
There is no indication here. Where is the filing listed? We have not included.
No,
Then
Lordship,
it however appears that the Learned Industrial Tribunal, being disturbed by the inaction on the part of the management of the petitioner, passed the order dated 24/2026, thereby directing the that the Lakshmi Tea Company Private Limited shall submit the proper and authenticated document regarding compliance of section 77 and 78 of the Companies Act 2013 on 18/5/2026, along with certified copies of the register charge kept under section 85 of the Act of 2013 in view of the agreement for sale of the specified assets dated 22/4/2019. It was also further directed that the payment that on the account, if there is a failure to do so, a cost of rupees 50,000 shall be imposed. It is under such circumstances the petitioner had approached this court by filing the present petition. This court have heard the learned counsels appearing on behalf of the petitioner as well as the respondent authorities. First, it has to be taken note of that it was at the instance of the petitioner that the learned coordinate bench of this court by an order dated 19/9/2022 passed in WPC number 5586/2021 directed the Learned Industrial Tribunal to decide the question of applicability of section 18 of the Act of 1947 vis-a-vis the binding effect of the agreement dated 6/10/1969. First, it is the case of the petitioner that there is no agreement dated 6/10/1969. And therefore, in that view of the matter, the directions so passed by the learned coordinate bench of this court for deciding the applicability of section 18 of the Act of 1947 vis-a-vis the binding effect of the agreement dated 6/10/1969 cannot be complied with. Under such circumstances, this court therefore directs the industrial tribunal to proceed to dispose of the reference case, being reference case number 2/2021, on its merits. And without insisting on the compliance to the order dated 24/2026 passed by the learned with the above the petition stands.
The alia of 112 hectares of land and 80 hectares of water body. And the annual revenue was 15 lakhs per year. Now, soon after taking possession, I have found it's full of encroachment. I have submitted the reclamation before them to demarcate and confer the actual the area and the boundary of the fishery. they have registered a demarcation case. And then they have found that only 78 acres of hectares of land exist. And out of 80 hectares of water, but only 50 hectares of water body is available. I have submitted my representation for refixation of the annual revenue and also for removal of the encroachment. They have made various correspondence, but till date nothing has been done. Now, after filing of the petition, I have been served with a notice asking me to pay amount about 29 lakhs as an area, as well as the current year revenue. I have submitted my representation stating all these things, my lord. This statement I paid.
Where is the notice inviting tender?
NIT has not been approved.
Huh?
NIT is not there.
So
LOA,
your entire representation is based upon the NIT.
LOA
Wherein
is also,
it is-
LOA
no,
is
no,
also
no.
there. LOA, can you find
As LOI say,
page 27?
it says about 80 hectares of land.
112 hectares of land and 80 hectares of water area.
Then 12 hectares of land and 80 hectares of water area with a minimum of a year. So fishery will be only restricted to 80 hectares.
It,
So here
but here the right to
it
enjoy,
has been found as 78.35 hectares.
that is land.
No,
Yes. So far as water is concerned, page 66, Lordship,
where is the report dated 6/1?
page 66, madam. Here. The representation mark page 67, detailing the all the factors.
The issue is that,
Consider that no coercive action or they will not proceed to cancel my the settlement.
this matter is being adjudicated, Lordship. Here the issue is that, Lordship, in the NIT, we have in the NIT, there was a clause, Lordship, as is where is basis, Lordship. So that is not being annexed here. So in that matter is being upheld by the revision bench also. That issue. Right now I don't have the order. But this clause, whenever this clause is there, but this has not been annexed here. NIT is not been enclosed.
NIT will be relevant. And the report also says that during the monsoon, it is inundated.
That period, even the fishing is restricted.
Maybe
After-
December onward, December to February, fishery may be swallow. So different thing, February and March. Thereafter it is inundated. Rains come. You are new into the business. Are you new into the business?
Seems so, because soon after getting the settlement, the letter of acceptance, they have deposited all the money, and then when they proceeded, they found the encroachment, etc. there. So immediately on 29/22, submitted the representation for demarcation. And process has been on, madam.
So you have not paid for 2023-24 also.
Have been cancelled.
22/23.
Huh?
So we have been cancelled also.
Yes, they have been cancelled.
Yes,
You have not paid.
yes. I don't know why.
You filed the tender. Without filing the tender, we cannot do it.
But they are also having the copy of the tender,
No, you have, Because you make your basis, your representation is submitted on 10/3/2026 or 18/3/2026 is on the basis of that only. I need see page 70. For the purpose of the proper adjudication of the issue, for the purpose of adjudication of the issue, and more particularly taking into account the stand taken by the petitioner in the representation dated 18/3/2026, it is the opinion of this court that without the notice inviting tender being brought on record, no notice can be issued in the instant proceedings. The instant petition cannot be entertained by issuance of notice. Mr. P.J. Sekar, the level senior counsel appearing on behalf of the petitioner, submit an additional affidavit to be filed, thereby bringing on record the said notice inviting tender on the basis of which the settlement was made in favor of the petitioner. This is the matter upon filing of the additional affidavit.
Case some mistakes caused by the petitioners when filing the writ petition. And accordingly, Lordship, in the order itself, direction was given to the circle officer Gusaigaon. Due to the delimitation, Lordship, the disputed land fell in the district of Dhubri now. But Lordship, when filing the writ petition, we made a mistake, Lordship, by making respondent number 3, District Commissioner Kukrachar. So we made respondent number 5, Circle Officer Gulakhan, but instead of district Dhubri, we have written district Kukrachar. So according
It is actually not for review for certain clarification.
I have already filed that was withdrawn. Because earlier respondent number 3 was District Commissioner Kukrachar, so now he may be treated as District Commissioner 3.
So we have to recall this order.
When paragraph 8.
And when did the delimitation happen? Then why did you make a mistake?
Thereafter, their addresses changed, Lordship, but the dispute was going on the basis of the old records before the review. The year 2022, Lordship, in paragraph 3, I have mentioned. Practically, they can, that Lordship demarcation was possible. So I now revision circle till 2022 for all practical purpose. Paragraph 18, your Lordship has directed us to move this from a competent. There is mention circle officer Saigon.
The present application is a review application. The present review application is directed against the judgment and order dated 9/3/2026 passed in WPC number 5378/2025. On the ground that on account of the delimitation exercise being carried out, the land in question fell in the Dhubri district, isn't it? However, the district commissioner district magistrate Dhubri, however, neither the district commissioner district magistrate Dhubri nor nor the other revenue authority in the Dhubri district were made parties in the instant proceedings.
The settlement officer.
Settlement officer has no business.
Circle officer, Gulabpur, revenue circle, but we have written district Gulabpur.
Understood. Therefore, I say that revenue authority in the district of Dhubri were not made a parties. Except the settlement officer Dhubri, who would not be in a position to give effect to the directions so passed. What did I do? You were the petitioner. What did I do?
Worship directed us to approach the competent authority and in the instant case, for the circle officer, Saigon, instead of circle officer, Gulabpur. Okay, right, in worship. Page 10 of the.
Osaigaon is not a party here.
Saigon earlier was a party worship, not worship. Saigon was not a party, but inadvertently it is written as Saigon. Instead of Gulabpur revenue circle, district two. That was the mistake.
What was the direction given in your favor? You have filed the petition challenging,
There was a dispute between private respondent and the petitioners
have
regarding.
approached this court seeking direction upon the respondent to record their names in accordance with the court order over 1 bigha of land covered by so-and-so Gosaigaon in the district of Bukata.
So earlier it was sign off, so inadvertently that
The case of the hearing is the decision in interest of the purchase of land. The respondent declared an mutation between these two and passed it. So, paragraph number 18, we just changed from circle officer Gosaigaon to circle officer Gulabganj. It would do nothing else.
So in the white
No,
paper-
nothing more. That is the only thing. This is a review application seeking review of the order dated. Judgment and order dated 9/3/2026, passed in WPC number 5378/2025. The review has been sought for on a limited ground. Inasmuch as there was a mistake, error apparent on the face of the record, whereby this court at paragraph number 18 of the said judgment and order dated 9/3/2026, passed in so and so, have mentioned that the petitioner were required to file their application for mutation before the competent authority, that is before the circle officer Gosaigaon. Mr. R. Chaudhary, the learned counsel appearing on behalf of the review applicant, submits that there has been an error apparent on the face of the record, taking into account that the orders that the competent authority would have been the circle officer Gulabganj. Inasmuch as the reference to the same have also been made in the previous segments of the judgment dated 9/3/2026. Taking into account that there has been an error apparent on the face of the record, there has been a mistake committed by the court, which is a mistake in similar to a mistake contemplated under section 152 of the Code of Civil Procedure, 1908. This court observed that the competent authority so mentioned at paragraph number 18 of the judgment dated 19/3/2026 shall be the circle officer Gulabganj in the district of Dhubri, na? And not the circle officer Gosaigaon. Accordingly, the instant order shall be a part of the judgment and order dated 9/3/2026. Here, there is nothing else. Here only that is there. You now have to file an application before the this Gulabganj.
I filed the application before Gulabganj, but his above authority is respect number 3, as was earlier mentioned as district commissioner Kokrata.
No, but you did not mention about those applications which were filed earlier in 2018. You kept all these applications there. You were awaiting the RSA.
But Lordship, we have already enclosed all those documents along with the declaration.
Not a case for review, only for correction.
So I'm praying for some accommodation. It can be taken up day after tomorrow.
Item,
Yeah, item 8, day after tomorrow.
this is for orders.
That amount of compensation by the teachers.
Oh, this matter.
Yes, my lord. Insurance.
Somebody was taking time.
No, Lordship, I received this one. They have submitted, subsequently they have submitted the affidavit in reply. Some clarification I will get, Lordship, day after tomorrow. From the authority, I get some clarification. In the mornings, I got a call from them. They are just trying to propose certain things. Day after tomorrow.
Mr. S.P. Chaudhary, the learned counsel who appeared on behalf of the respondent number,
For the respondents, Lordship, yeah,
for all the respondents submits that he requires a week's time to
only
file
one day,
the-
Lordship. Day after tomorrow. Itself. I also don't want to keep pending.
to obtain the instructions pertaining to in pursuance to the affidavit in live file day after tomorrow. First, let's just back again on 18th of May 2026. Mr. S. K. Chaudhary shall ensure that the instructions are available. Okay.
And I have a telephonic conference. He has already asked the equity on the consult to submit the case demand proposal so that he can, the amount can be paid within this 2 to 3 months. The chief engineer newly joined work. He has already directed the activity concerned work. The civil engineer concerned to submit the test proposal. The test demand is to be submitted work. And like 50 days demand comes.
So when are you going to make the payment?
Approximately later in the month. Why? Because the new budget,
In the meantime, you make the payment. You don't pay interest.
I think they made in the last part of July of the application.
While as the part of anyway, we are not working for the first 15 days. Then obviously, when it's first and last, first obviously cannot be. So on
Not obliged.
15 would be the last, the starting of the last. It's an application for alleging willful and deliberate violation to the order dated 6/10/2021, 20, passed in WBC number 7353 of the, huh? 70, 7353 of the 2018, whereby there was a direction upon the chief engineer irrigation department to release the admitted dues of the petitioner amounting to rupees 57,91,047 within a period of 4 months from the date, and failure to do so, it would attract interest at the rate of 6% per annum on and from 8/10/2018 till full and final payment is released to the petitioner. On account of the non-compliance to the said order dated 6/10/2020, passed in deputation number 7353 of the 2018, the present application has been filed. Mr. N. the learned counsel appearing on behalf of the Irrigation Department submits that already directions have been issued to the executive engineer to submit the necessary proposals for payment of the amount admitted dues of the petitioner along with the interest. Interest has to be citizen compliant with, because you cannot say that. Because then you will have to go for review along with the interest. And the said payment will be made in 2-3 months time, in 2 months time. It is relevant to observe that the learned coordinate bench of this court, by the order dated 6/10/2020, directed the chief engineer irrigation department to release the amount of 57,91,047 within 4 months. Admittedly, the said amount have not been released, and resultantly, as per the direction passed in the order dated 6/10/2020, interest would accrue from 8/10/2018 till the date of payment. Delay in payment the delays so caused by the respondents in making payment has to be therefore defrayed from the public exchequer. The respondent authorities, the chief engineer irrigation department, is directed to apply this form as to why the interest which have been imposed had to be paid, should not be recovery from the erring officials of the irrigation department, concerned irrigation department. In that regard, the chief engineer irrigation department is directed to file an affidavit before this court. This matter again on 27th of July 2026. Affidavit be filed by the chief engineer irrigation department on or before 22nd of July 2026. It is further observed that if no payment is made, it is further observed that the chief engineer irrigation department shall also the chief take effective steps in consultation with the other authorities for relief of the payment of the petitioner.
Remaining amount of it.
The remaining any amount payable to the petitioner in pursuance to the order dated 6/10/2020, passed in WPC number 7353 of 2018, on or before the next by 22nd of July 2026.
The private business.
No steps. You don't want the response number 3. Strike his name out. Then we'll see whether the petition is maintainable or not. Take out the Dibrugarh Municipal Board. Okay. You're not taking steps, so we strike out the name of the respondent. And thereupon the petition will fail.
Even otherwise, they are not necessarily paid. They are claiming money in persistent private contract executed by the petitioner and the private respondent number 8. So respondent 1 to 7 is nothing.
Between the petitioner and 8. And
the petitioner is
asking the money from whom?
all the respondents.
Why? How many years of practice? Huh? Mr. H.K. Sharma, the learned counsel appearing on behalf of
8 and 9.
respondent number 8 and 9. Admits that the dispute is between the petitioner and the respondent number 8 and 9, which are private civil disputes.
There is an arbitration clause.
Private civil,
Yes.
private civil dispute. And as such, the petitioner cannot be permitted to initiate a public law remedy by filing the present petition. He therefore submitted that the instant with petition ought to be dismissed or not to be entertained, rather dismissed at the threshold. Ms. So appearing on behalf of the petitioner submits that she has obtained instructions. List this matter again on manager senior coming on 18th of May 2026, on which day this court shall consider and shall hear from the petitioner as whether the instant petition is at all maintainable. My admission, huh? What is this? Issues to be framed now.
We are finding the WS today, we have set the copies. Just to be
You're filing it today?
copies are already served to all the.
Yes, ma'am.
Okay, next step, you are filing it. So we fix it for draft
Okay.
issue.
Yes.
Taking into account that the affidavit, the written statements, the pleadings are complete, comma. This matter again on 9th of June 2026 at 2 p.m. So the parties are directed to provide the draft issues. Are directed to file their draft issues before the registry of this court on or before 5th of June 2026. By providing copies to by providing advance copies to the other side. This is the matter on 8/9/2000, 9/6/2020 for settlement conditions.
Purchase.
Wait here. H. Gupta. This is for your rejection, but who is eligible in Hindustan state?
That's in they've already, the work has already been awarded.
Then what do you mean?
In fact, that's not a fact.
You're saying infraction. The Eleventh Council appearing on behalf of the petitioner submits that the instant petition has become infractuous. And the petitioner has become infractuous in as much as the work order has already been issued to the response number 4. 4.
5, not
Response number 5. Has been already issued to the Hindustan Steel Works Construction Limited. Further to that, the Eleventh Council submits that the petitioner would not press the instant petition. Accordingly, the instant petition stands dismissed.
Contempt, the order, the 2/5 of 25.
Yes, they have.
When are you paying?
They are taking samples of the structure they have given. I think it is some sample. I shall file an affidavit.
My question is, kindly see the order I paid 11 lakhs. There's already a sanction. That is the stand para of the affidavit filed by respondent. Deponent begs to state that the financial was accorded by the sanctioning authority on demand of right to ensure within the year, but the FOC upon the year amount is not received from the sanctioning authority within the financial year. However, steps have been taken to revalidate the sanction. Once revalidate sanction of the FOC received from the government of Assam, steps will be taken to credit the amount to the bank. Now, the question is, this direction was passed on 5/2025. Does it take more than one financial year for you to reach? Next week. No. It for them matters. I don't understand some verification is different, but here is the question, there is a direction for invalidating. They have taken that. So if you have taken, does it take 1 year for you? What does that take 3 months? And at that point of time, you have the budget also. In fact, but why not interest now? Interest? Interest you have to pay. Because you can admit amount. Not only an admitted amount, it is the case at the state of finance validation of sanction. Which department? Police said, did they have a good card? You want the card?
Yes.
You want the card? Give the card. That's the card. That, I see. The master order, fetching the card. Can you be? Nani? It is for non-payment of the year. Vehicle hire. You give it for hire. Can you cover the statement? Cannot happen like. I'm doing the some verification. This is the case of allegation. You said, what is the stand? Kindly see for the court. The financial sanction was accorded by the sanctioning authority on 25 with financial sanction number so and so, but the FOC against the sanction amount of year is not received from the sanctioning authority within the financial year 2024. However, process is being taken to revalidate the sanction. Once revalidate sanction and FOC is received from the government of Assam, steps will be done. Then why why the people asking orders who are not complying with this simplest? List this matter again on Mr. T. Nath appears on behalf of the respondent number. On behalf of the sole response, sole contempt. The present application has been filed, alleging willful and deliberate violation to the order dated 2/5/2025, passed in deputation number 1166 of 2025, wherein there was a direction to revalidate the financial sanction for payment of the admitted amount of rupees 10,54,302 to the petitioner within a period of 3 months from the date of receipt of the certified copy of the order. It is very pertinent to take note of that the learned coordinate bench of this court, while passing the order dated 2/5/2025, have categorically taken the stand of the respondents in the said this proceeding, wherein it was mentioned that the financial sanction was accorded by the sanctioning authority on 25/2/2025 by financial sanction number FS/POL-24-25 4553 dated 25/2/2025. But the FOC against the sanction amount of rupees 10,54,302 was not received from the sanctioning authority within the financial year 2024-25. It was also mentioned that process were being taken for revalidating the sanction. And once the revalidating sanction and the FOC is received from the government of Assam, the amount will be disbursed and credited to the petitioner's account. It is under such circumstances the learned coordinate bench of this court directed that the said amount be deposited within be the said amount be paid by revalidating the sanction within 3 months from the date of receipt of the certified copy of the order. Thus, taking into account the above, this court that the instant proceedings to be listed on 8th of June 2026. It is observed that if the amount of rupees 10,54,302 is not disbursed to the petitioner in the meantime, this court would be constrained to impose interest upon the respondent, upon the erring officials of the police department of the government of Assam, and upon the respondent police department, upon the police department of the government of Assam, upon the home and political department of the government of Assam, and such with effect from the date of the order dated 2/5/2025. Now with effect from 25/12/2025.
Last question.
And such amount of interest so payable shall be recovered from salary of the erring officials of the home and political department.
But the instructions they have said that the entitled amount of the petition is 10 lakh.
There may be why you are not paying. Mr. Lal, whenever you file your affidavit, you have to look carefully. You file your affidavit and categorically say that this amount financial sanction of the crime. And after that, you keep on changing. I'm not on that. We will pay like 11,000 and so something will happen. But you don't pay this amount only. The amount entitled to the person. The amount entitled is not this one.
This is as per office made it.
What is the item?
Notice written by penalty instructed and.
Yeah, then we strike out the name of the respondent.
May be allowed to. Notice on the plastic. Plastic may be allowed.
Want to search by way of the state. Wait. They can appear na. Cooperative. Will they appear represented by the secretary? Nowadays, the secretary, in view of the judgment of the Indian man, I have some problems with accepting it. He has been given the status of a chief executive officer, isn't he?
Cooperative society.
They're not aware. So, he's sitting in this four corners of the room.
Priority department of cooperative.
Issue came from the case of the judgment which passed by the. Very means say that when there is a dispute as regards the termination of the second, the society has raised the cooperative society that no business and neither the petition can be filed. It is an issue which can be the appointment by a personal service. And under such as it is an appointment by person, it's a contract of person in certain case to go with. He even can't go to the civil court, nothing to do. It is different. He may ask for them. That is what it is. matter went to the division bench. Division bench interpreted the term secretary to be same that of the chief executive. Is the chief executive officer, you can fix it, you can accept.
If it's CEO, then I
I'll
can.
give you that. You are not aware.
Some other advocate appeal. No, other advocate appeal.
That matter, the judgment was passed by Justice Manichur. Indian bench judgment was passed by Justice, the Chief Justice along with Justice Mandate. Matter never came to me. I was nowhere in the connection, but I know, but it was from the protection department. You
Lordship,
should be aware of that.
Lordship.
Okay. It is seen that the service upon the office note dated 8/5/2026 mentioned the service upon the respondent number 7 is not complete on account of insufficient address. Ms. M.D. Bora, the learning planning council of the respondent of the corporation department supports that that she can accept notice on behalf of the respondent number 7. Accordingly, extra copy of the petition be served upon her. This you will buy tomorrow. You have date. List this matter again on the file of affidavit.
Lordship,
Stays there.
the put in civil supply, Lordship. Supply is the main exported here, my lord.
Okay, no problem with that. Okay, list this matter again on no urgency. What's the month? June month. Month of August? June month. I need the urgency. On, okay, we, in between both of us. 20th of July 2026. The student supplies department shall bring on record its stand. In the meantime, the respondents shall bring it on record their stand by filing the affidavit on or before 15th of July 2026. So that we have for admission date.
That I'm appearing on behalf of Mr. Peter.
Appearing for?
Respondent number 7 and 8.
Appearing for 78.
On behalf of Mr. PJ Fukun, landed spending counsel for KK Indicus of English.
You're appearing for?
On behalf of Mr. PJ Fukun. PJ Fukun, Pranab Jyoti Fukun. Landed standing counsel for KK Indicus.
So the service is complete. It seems that Mr. Soinko appears on behalf of the respondent number 7 and 8. Taking into account about the service upon all the respondents are complete. It's the matter for admission on 22nd of June 2026.
God bless you.
There is a technical problem in this petition. The respondent number 6 is not the owner of the wine shop. Husband has been included as a owner of the wine shop. I appear for the owner of the wine shop, who is the wife of the respondent number 6. We have filed an application today. Okay. Opening.
So you are
I'm the owner of the wine shop.
the respondent number 6 is not the
Lord Chakra, what happened?
And what are you doing? Why are you disturbing or you?
That's the name of the Tafik Rahman was reflected, Lordship, in the front of the wine shop. So we believe that the license holder is Tafik Rahman.
We have filed it today.
Query.
I have the copy.
Respondent number 6 is Tafik Rahman. Tafik Rahman is the wife of
Husband.
Oh, the wife is the owner.
Just now.
He has to amend it and you
You are in the business of liquor.
Well, even now, non-veg restaurants are operated by, by title of Sahara also. Well, money knows no religion. Money knows no religion.
You are kind of naive. What?
For, but because any order pass will affect me, or otherwise he has to.
Are you telling that I let him try?
Yes. Yes, sir.
I'll record his submission that she is not the owner of the well. That will let him place out and file. Do this.
Provided lordship take the details.
That's okay. That is your submission. Then whatever they want to do.
We file an IA, Lord.
The instant application has been filed. No, the present proceedings, the official belief that the service upon the respondent number 6 that believes that dated 8/2026 will be that though the AD cards have not been received, but from the track but from the postal consignment report, service have been effected upon the respondent number 6. Be that as it may, Mr. R.R. Gogoi, the learned counsel appearing on behalf of the petitioner submits, on behalf of the respondent submit, there is a license in respect to the roadside wine shop name. The name is roadside wine shop.
Roadside.
License in respect to the shop with the name and style inverted comma roadside wine shop. Have not been issued in favor of Tafik Rahman. It is the wife of Mr. Tafik Rahman who is the licensee of the road of the shop, inverted comma roadside wine shop. Mr. D.J. Das, the learned counsel appearing on behalf of the petitioner, submits that he would file appropriate application. List the matter upon such application.
Oblige you.
Why you are filing? How filing? They're running it. Yes, Mr. God, it's item by 18. AD card on 2, 3, and 4.
Official data settlement is wherein the private hospital 5 is
Still pertains to what?
but what is it? Connection of tolls from the parking lot.
What?
Connection of tolls from the parking lot. What should the tender was issued on 4/26.
Okay, do one thing.
Thereafter,
You do one thing, Mr. God. Who is looking for 5? I know.
5 notice was there. Consignment, he did not receive lawsuit. He refused to receive the consignment.
He has refused to
Refused to receive the
trustee.
yes. What? Not trustee. It was sent, but through people.
Authority of the postal journal of reform number 2 is with the what about 5?
But that's refused to accept.
The answer notice upon respondent has been received. Answer.
Answer, because he has requested to receive lordship.
No, it is not received. You were. You do agree. Take service by way of testing upon the respondent number three. Five. Can you do that?
I can do.
Okay. Then we can do this.
Because without opening the tender lordship, that order was issued lordship to the respondent number 5. No tender was opened lordship.
So it's the all between the problem with the municipal body being they are normally not being represented by the councils here. They have their different now. So let us take service by it. Later on they will come and look here. And that was not. So we have to make sure we have it in the month of use.
First part of June lordship.
First part of June not possible. Because we will have it in technical. The official reveals that service upon the respondent number 5 is not effective, as the notice has returned unserved with the remark unserved. As regards the respondent number 2, 3, and 4, though the AD cards have not been received, but the postal consignment notes read for a postal consignment number tracked on the www.indiapost.gov.in reveal that service that the items have been delivered. Considering the above, it is the opinion of this court that service may be that a further service is required to be effected upon the respondent number 3. 3 or 4, 2 or 3 and 5. On the respondent number 3 and respondent number 5. Mr. Ado, the learned counsel appearing on behalf of the petitioner submits the petitioner will take steps by way of the scheme. Taking it into account, the above, this court directs the petitioner to effect service upon the respondent number 3 and 5 by way of the scheme to the registry of this court and file an affidavit of service on or before the next day. The petitioner should ensure that the service is effected upon the respondent number 3 and 5 on or before 29th of May 2026. This matter again on 10th of May, 10th of June 2026. Admission subject to filing the affidavit of service as directed.
Comments reports. Part of one. I did page 13. Yeah, 24. Page 44. So technically, the entire amount is being your directions will given. The earlier installment. We have your
The instant application has been filed. Opinion of this court that the opposite party number. The parties in the instant application. Thousand twenty-three. The opposite party numbers, opposite party during are arrayed as respondent number, content number three. And application. Registration on the basis of the state memo parties in the order passed during. Make necessary changes in the post title and update the same post title of the accompanying content application and update the same. IS stands disposal. Main case to be issue notice on the newly included opposite part respondent numbers three, contempt number numbers 3 and 4. Steps to be taken by way of speed post within 3 days. The notice is returnable on 15th of June, 2026. In addition to that, liberty is also given to the petitioner to effect service upon the respondent number, opposite contempt number 3 and 4 by way of the state. Put it to the registry of this court and find an affidavit of service on the next day. Effect by trustee shall be made. The petitioner shall ensure that the service by way of trustee is effected upon the respondent number 3 and 4 on or before 1st of June, 2006. On payment. On 6 months, 6 more, 5 months. Till that, that will, then, but now my colleague is. The validated with. So, sorted to be, I'll confirm that my, the logic. The MCT, the learned council, the learned government advocate, and state before the school and instruction issue. Woman, dated 29/4/2026, very. That as regards the original copies of the validated fields and vouchers pertaining to the petition have already been submitted to the office of Commissioner of Panchayat and Rural Development, Gauhati, the Department of Gauhati, to the office letter dated 2025. The said communication is kept on record and marked with the letter X. Equal to that, the communication dated
2026 of the District Commissioner bracket in charge Lakhimpur, admitting the liability of the petitioner to the tune of rupees 5,93,943 have also been placed before the court, which is kept on record and marked with the letter. In that view of the matter, the Panchayat and Rural Development Department is therefore directed to apprise this court why the petitioner have not yet been made the payment. To submit this matter again on 17th of June 2026. In the meantime, an updated status be placed before this court as to whether the payment of the petitioner have been disbursed, and if not, what is the stage of processing of the bills of the petitioner. Well,
I hope that in Excel 3 madam, petition of the government, madam, that is 10/8/22, whereby petition was taken to provide madam that price of license to the tea garden management. Petitioners are all the fair price of licensing. They are operating their fair price of the vicinity of the tea garden area. Most of the consumers of their fair price of tea garden level.
you are referring to Alexa?
Hello?
What you are challenging?
Alexa 3 man.
I think for the meeting for fixation of minimum wage for plantation. Or
That was the meeting, madam. Lordship will find in the next page, madam. Next page B. The garden management will be provided licenses.
Ah. 3B.
Yes, madam. 3B. Page 3.
Okay, then what? Why are you aggrieved?
We are the fair price of licensing existing. Our license are till June 2026. And most of the consumers of the present fair price of petitioners are the tea garden laborers. If the this management authority is provided with the license, then their consumers will be drastically some of the according to their affidavit itself, at present almost 1,300 something.
The council will to dynamics. Why the tea garden authority has been allowed to be first the tea garden worker. Reason being, as regards the minimum wage fixed. When you are fixing the minimum wage, see the computation of the minimum wage also includes certain amount as an amount paid by the management.
Yes, that is the tea plantation management act. That is another
No,
this is under the NFSA.
tea plantation management is a different. Tea plantation of Labor Act 1951 is on a different scheme.
Yes.
Now, what they do, they include within the minimum wage fee fraction of the income. So when they pick it out there, the assembly, what they have done now here is they have allowed it to be distributed to them. It is free ration.
Yes, under NFSA.
Now, once this free ration bills have been given, that is adjusted against the minimum price.
That is one aspect of the matter, Lordship. But on last date, Lordship, I placed one instruction dated 6/4/2026, if it is there, Lord. 6/4/2026. One single page.
If the issue in go, the try to find out whether the petition as regards the fair price license existing in the year in existence is on.
6-4 lots of instruction was furnished to me. Although a scheme was initiated, Lordship, but no action to execute the same has been taken on the matter since 2015.
So that decision which was given was not put into, but challenging of here has not
Given
been,
effect, the decision that was silenced, Lord.
has not been given effect.
Yes, Lord. Till date means on, as on 6/4/2026. So I think in this matter, Lordship,
They have not taken any action.
About the, after that matter, Lordship will find case 56. Case 56, the director of food and civil supply issued letters to all the deputy directors, assistant directors, superintendents. 28/9/2020. Annexure 5, case 50. As personal to that matter, new management already applied also. They have admitted in their affidavit. And have also admitted, madam. So it is aware that there was this policy of the government that the fair price of having the below 50 numbers of consumers will be merged with the nearest fair price of having more. So madam, if this policy is allowed, madam, be implemented, then madam, most of the madam, fair price of e-commerce under madam, below 50. Some of them even madam, consumer numbers will be nil. So madam, they have admitted in their affidavit that if the applications already which has been submitted before them, then 707 numbers of fair price will be come under below 50.
383 applied. And because of this 383 application, 1384 number will be affected. Out of which not 707 are already below 50. So they are going to merge with their, because of it. Not because of this, they are already their cardholder number is updated. So one another policy is already there.
That I know, that I have a good. But there in that case also I held one thing. That it is the state who needs to provide the beneficiary benefit to the end beneficiary. That was the problem. The fair price shop is a material. So they don't have a vested right to challenge the action to have more fair price shop or less fair price shop, whatever may be. So therefore, I held that the decision on your part, the part of the government, to have to discontinue actions of having less than was permissible.
Yes. So in the mean,
That matter has also attained finality by the decision which
So out of this 1384, 707 is already out of the 7. We have already currently in the meantime, they have marked the nearest number. But my only concern is at this stage now. When if Lordship takes up this matter today, Lord, it will be mere academic if the authority ultimately decide not to give effect to the scheme initiative. So let me have that concrete instruction, Lordship. That is one priority. Or Lordship may dispose of this matter, giving them the liberty if in future authority decides to implement this scheme, they will file under it.
the council, I think it is better. Taking into account, they say that since 2022, they have not taken effect. So therefore, you approach this court event and effect this thing. Taking into account that this take time, it has been given by the secretary to government of Assam. Then public distribution, it says on 40 of here that I am directed to inform you that although an initiative was taken for issuance of fair price shop license to tea garden management to facilitate distribution of food grains under NFSA, the existing tea garden workers who garden management but no action to execute the same has been taken on the matter since 2022. Therefore, let me close it and go again now. Otherwise, I can very well apply the law which have otherwise have held in the other judgment, which will go against you. Because if you see the judgment, what's the judgment? I categorically held that those paper shops did not have the local standing in view of a judgment of the Supreme Court. For our something. Okay. So, 2023, I tailor. Yes. Joy Bora and others versus speedometer. Further to that, in a very recent judgment of the Supreme Court in the case of Gauhati, Dr. Devi versus State of West Bengal, 2022, SC 691. Supreme Court have reiterated the same position at paragraph number 25 here. This court in so and so held that no person can claim a right to a fair price shop, to remain at a fair price shop. Right? A fair price shop, an agent of the government, and he would only have a right to be considered for appointment. In this context, this court observed that there no one can claim a right to run a fair price shop as an agent of the government. All that he could claim was a right to be considered to be appointed, the appointment to run a fair price shop. If the government took a policy decision to prepare cooperative societies for appointment as agents to run the fair price shop, in the light of frustrating and unfortunate experience gathered in the last 2 decades, we do not see how we can possibly hold that there is any discrimination. Therefore, or in this regard, this is said in the judgment in Gauhati Dr. by Supreme Court. Right. So you have to.
That is true, brother. I am referring to the order to targeted public distribution system order to 2015. Here, licensing and regulation of fair price shops. Clause 5 says that license to the fair price shop owners shall be issued keeping in view the viability of the fair price shop. And that was taken into account by this honorable court in a judgment delivered in the year 2000. I have annexed in my reply affidavit also, my lord, where it is stated. There is an instance.
We have also taken note of that judgment. When you are mentioning about that judgment, I have taken note of in this judgment. That there was I think that was the judgment passed by, I think this is usual way.
No, my lord, that is for 2000, my lord, 2002. That was delivered by honorable justice, my lord. Change.
So there it was mentioned that you have to look into the viability. The viability also when you are looking in. But that is a different thing from the question as regards the right. The right, whether you have a right to question, you have a right for appointment.
Yes,
Initially be considered for appointment, but can you say that the government does not have?
no, madam, I'm not saying this, madam. Like, in that case, madam, Food and Civil Supplies, madam, department. Food and Civil Supplies Department, submitted an instruction. Madam.
Can be other judgment of the Supreme Court in the case of Sarkari Sasta Anand Director South Asking to. The Supreme Court categorically observed that if you want to run your area, you can very well run your fair price shop in your panel, but you cannot become an agent of the government. Earlier, we would like to we have referred to the abuses which have been known in the prevailing system of welfare under remand. The system has deteriorated and become completely unworkable here. An absolute and overall of the system has become compulsive if the population of Madhya Pradesh were to receive a regular supply of the ration. It was in those circumstances that the government came to the conclusion that cooperative society would be the best method of distribution by which the food could be delivered, that is, ration could be supplied to the consumer. One can doubt the positive and progressive the cooperative societies are expected to do. Here it says the fundamental right of the trader like the petitioner carrying the business in foodstuff was no way affected. They could carry on the trade in foodstuff without hindrance as dealers. Only they could not run the fair price shop as agents of the government. No one could claim a right to run a fair price shop as an agent of the government. All that he could claim was a right to be considered to be appointed as an agent of the government to run a fair price shop. If the government took a policy decision to prepare cooperative societies for appointment as agents to fair price shop, in the light of frustrating and unfortunate experience going forward, we do not stay free. So therefore, your thing would be better not to go as per this and they again approach to it. Otherwise, this is the case, therefore I say. This is the case for dismissal. Otherwise, long as
Well, I am, may kindly come to my reply affidavit, page 78 at once. And
Hello. You want this to go to into this, okay? You are referring to
only
this
one
judgment,
paragraph,
na?
only one paragraph.
Okay, here, there is an instruction by the Food and Civil Supplies Department of India for management of public distribution system and viability. In that instruction, it is stated that the national norms of fair price shop are 2005, but there are in some places where by maintaining that minimum norm, the authority may appoint new dealers according to the writ application self-stand. But here, nothing is being mentioned as regards your right to remain as the fair price shop. But that cannot be the law. Oh, see, the law have changed after the 2015 targeted order. Anyway, you want that dismissal, I can't have.
Well, let there be, well, they have stated that.
They are saying that we have not taken any action. Your submission therefore should be, if any action is taken, let me come back again. Otherwise, it's the case for dismissal. It's covered by my judgment.
Their instruction, let it be there, let them listen more than that.
Better.
At this moment.
Heard Mr. N.K. Kulkar, the learned counsel appearing on behalf of the petitioner. Mr. P. Nayak, the learned additional advocate general, appears on behalf of the state respondents. By the present petition, the petitioner have assailed the decision taken in the meeting held dated 10/8/2022 and the communication dated 28/9/2022, whereby a decision was taken to grant issue fair price shop license to the management of the tea gardens. Although various issues have been raised in the instant proceeding, but it is relevant to take note of that in pursuance to an order passed by this court dated 6/3/2026, Mr. P. Nayak, the learned additional advocate general, have placed before this court an instruction dated 6/4/2026 by the Secretary to the Government of Assam Food, Public Distribution and Consumer Affairs Department, dated wherein it is categorically mentioned that although an initiative was taken for issuance of fair price shop license to tea garden management to facilitate distribution of food grains under the NFSA to the existing tea garden workers through garden management, but no action to execute the same has been taken on the matter since 2022 till date. The said instruction is kept on record and marked with the letter X. Mr. N.K. Quilter, the learned counsel appearing on behalf of the petitioners, submits that taking into account that no action has been taken by the respondent authorities since 2022, the petitioner would not like to pursue the present proceedings. However, however, liberty may be granted to the petitioner in the circumstance such decision is taken to again take steps for issuance of fair price shop license to the tea garden management. Taking into account the above instant with petition therefore stands closed. Liberty, however, is granted to the petitioner to approach in the circumstance any steps that are being taken for issuance of a fair price shop license to the tea garden management, if so advised. Otherwise, that is. That means. What is this? Non-payment. Which department?
Last together, we are included as a party.
Huh?
Last together, we have included as a party.
I know.
This was issued from that time. However, they have not started booking. Service could be available. Have started.
Mr. S. Dutta, the learned standing counsel of the Revenue and Disaster Management Department, submits that they have been implemented only on 13/5/2026 and on 23/2026. And thereupon, notice was issued on 13/5/2026. And notice was issued. And notice was issued thereupon. The learning council, the standing council submits the till date, no steps have been taken by serving extra copies upon them, upon him. So taking into account the above, list this matter again on 14th of September 2026. In the meantime, steps be taken, extra copy of the writ petition be served upon Mr. S. Dutta, the standing counsel of the Revenue and Disaster Management Department. Gusto. As the Gusto. This goes further, directs all the respondents herein to bring on record their stand. All the concerned respondents herein to bring on record their stand by filing their affidavits on or before 28th of August 2026 as to whether the petitioner is entitled to the amount so claimed, and if not, and is entitled to the amount so claimed or any other amount.
May I please, your lordship? Lordship, in this matter, lordship, it is related to payment of some pending bills, lordship. To this effect, the respondent authorities have filed in their affidavit have also acknowledged that, and a part payment was done. The rest of the amount, lordship, it is yet to be paid, lordship.
There's some work being done. What has happened in the meantime?
Received some instructions. 24.
What is PIP? Proposal in principle.
Lordship. Not sure myself.
Huh?
I'm not sure myself.
You are finance, you are PWD, you are health, you don't know. It's M. Viana. Look. The learned counsel appearing on behalf of the National Health Mission Assam submits that the liability to pay the amount of 52,45,478 to the petitioner is proposed in PIP 2026-27, which is under approval. Further, a working estimate was also submitted by the PWDB, which is also under approval. Upon receiving the approval of the PIP 2026-27 and on approval of the working estimate, the final bill amount would be released to the contractor subject to availability of the fund. And in that regard, an instruction dated 13/5/2026 issued by the officer on special duty NHA was placed before the court with respect of report and marked with the letter X.
Program implementation plan.
Program The learned counsel appearing on behalf of the petitioner, on the other hand, submitted that the final bill of the petitioner, the bill submitted by the petitioner was in the year 2022. And there is that, and under such circumstances, and the work was duly completed to the satisfaction of the authorities concerned. Under such circumstances, delay in dispersal of the amount affects the rights of the petitioner. Taking into account the above, this matter again on 22nd of July 2026. In the meantime, the PWDB, the National Health Mission assigned, as well as the other concerned respondent authorities shall take due steps for finalizing, for getting the necessary approval so that the amount would be disbursed to the petitioner. First, it is further observed that the concerned respondent shall on the next date apprise this court as to whether the amount payable to the petitioner have been disbursed, and if not, what is the present status of the proposal for disbursement of the amount.
Present matter pertains to not appointment of regular retail outlet petrol pump dealership, my lord, in the district of Durham. I was, my lord, provisionally selected, my lord, and thereafter I was asked to submit the fees to 50,000 and related documents. I submitted the fee, my lord, and my lord, I submitted the land documents also for, my lord, opening up of the project. But one problem cropped up, my lord. It was a lease deed, my lord. And my lord, inadvertently, my lord, because at the time of, my lord, when I was, my lord, the process of registration of the lease deed was undergoing, my lord. One aspect was identified by the registrar that, my lord, the date of lease deed, my lord, it was stated by my counsel that it will commence in a future date. So it was identified during the registration, and that was subsequently, my lord, rectified. But my lord, inadvertently, while I uploaded the documents, my lord, I uploaded the wrong document, my lord, that, my lord, the unrectified document. So that was the problem, my lord. So my dealership was rejected, my lord. Whereas, my lord, in they have a provision, my lord, Indian Oil Corporation, my lord, that within 21 days, my lord, a chance, I should get a chance to rectify, my lord, any defect, my lord. I filed my representation also, but my lord, according to them, my lord, they have not received the representation at all.
You have been put in category 3.
Category 1.
Where in category 1?
Category 3, my lord.
Judgment has delivered again. Any judgment has delivered again.
Yes. I think, I would say
the petitioner. I thought. We regret to inform you that your candidature has not been found to be or arrow leadership on pages of documents submitted by you. Now, my lord, see.
Let us read page 138 better.
138. You are-
Because the other one, there are a lot of spelling mistakes. The word offered has become suffered. Yes. Isn't it? Mr. Sharma, kindly come to page 137. Applicant has suffered group 1 land.
But the more important point, my lord, is
We can read 138 properly. Applicant has offered group 1 land in the application. Accordingly, applicant has taken the land on registered lease which is executed before the submission of the, however, clause 1 of the lease deed says that the lease deed will commence from first day of April 2024, which is the date of future. This means that the applicant has not no ownership right over the land on the date of the application. Hence, applicant is found ineligible. So the question arises here as to whether the 19 years, 11 months, 19 years, 11 months deed to commence on the date on which you are considering the application. Or is it subsequent when you are going to give it?
now, I think I just states that effective date is 1. That is what now that we have taken 2024. Now, my lord, for a moment, not kindly come to 156. Page 156. This is the lease deed which the petitioner has submitted.
Yes.
Now, your lordship will kindly come to page 1.
Yes.
My lord, see that this lease deed coming from that is 22nd day of September. But the IUCN does not tell you the record. IUCN is tendered with the and here, I not will see that the lease deed is effective on 22nd day of September. So regarding this discrepancy, my lord,
When was the application filed?
my lord, the application was filed on 24th of September 2023.
So this is the document prior to that.
By way of additional affidavit. My lord, will kindly come to page
170.
170. The exact same document. That is same. My lord will kindly.
111.
It starts from 170.
You give a different number.
Now 170.
It's been different.
Yes. And this was the mistake.
How is it possible there is
That
different?
That is my case. That is my case. So, my
Okay,
I-
show me the original.
original, my lordship, the circle senior sub registrar at page.
No, where's the original?
Original, my lord,
No, original. Original document. Where's the original document? Show me that. Because why these are the different? This appears to be certified to be. This is not a certified copy.
This is my lord.
certified copy.
One which is annexed with the petition and the one submitted by the senior sub registrar in its affidavit. He is the respondent number, my lord, 5.
Ah.
So this document is there in the office of the sub.
Now, what is
registrar.
this document at
my-
page 170?
That is what, my lord. So at the time of registration, my lord,
Ah.
this anomaly was found out by the sub registrar
Ah.
and it was rectified there and then. My case is, my lord, when I uploaded the document, my lord, inadvertently I uploaded the non-rectified document and I filed a representation stating.
No, I'm not on that. I'm not on that. You see, this is an affidavit filed by senior. Where did you get this document? The council, how did you get this document?
My lord, this is the registered document, my lord.
This is an affidavit filed
page
by
number-
Chaudhary. How did
Yes,
you get this document?
Page number 147.
Where did you get this page 170?
The 170 was bought by us on the ground for the IUC.
Where did you get this document?
Was submitted by them.
Maybe that's a different thing. I'm not on that. Then obviously you have a chance for giving him under 21 days for making correction. That will apply. You see, a document which was otherwise submitted. Here his case is when he submitted it online. If he had submitted the document online, there was some mistake to that effect, wherein it was said that it was from 1/10/2024. What is 24? What is the 1/4/2024? What it is mentioned out here, but it was dated. This is the document. But your specific stand in many cases of IOCL, BPCL, all these cases are specific. That if there is a document which exists prior to the submission of the tender, and that document exists, and if he has that original document to that effect, that is why I'm asking him, if he has the original document, because this is not a certified document. If he has the original document, you should have taken out the certified copy from him and looked into and found out.
Actually, either they submit the application form stating whether they have land under land 1, 2, or 3. After their provision is selected, we see documents from them. When we saw document from the petitioner, the petitioner furnished us with the document for lease deed, which would be existent or would be in force from a future date.
No, he did not do that. Show me where, when did you
Yes,
you have, what you are making that statement that at the time of verification, initially you have provisionally selected after the lottery. So once you have provisionally selected, you have next stage is for going for verification. When you went for verification, did he submit this document?
Verification not done. No opportunity.
Then
I don't will kindly come, for a moment. We sent them a mail on 19th day.
Whatever matters I've done, many. Not with IOCL, but the BPCL and a lot of matters are there. We appear for BPCL. So here also same, but the consistent stand we put there. If that document was prior to the submission of the tender, because they have delivered many judgments on it. If it is a document which is in existence prior to delivery of the submission of the tender, then obviously you can give any other date that you even allow, because the terms and conditions are all similar. So here you allow to produce any document which are prior to the submission of, but post that you don't allow. This is what I have also held in many judgments. Is there, Mr. P. Hurt was all oil, all 4 3 oil council. That is it. That is what it is, simple question. Now, therefore, the question is, you have to ask whether that was the document which was there. If it was 1/4/2024, but later on actually asking for the certified copy or the original and find out. This is what you should have done.
Verify this then, my lord. Respondent number 5, my lord, is the senior sub-registrar who has executed this document, my lord. Page number, my lord, 1.
No. Forget about the respondent number 5. You do it by yourself. Have a look at the original document.
Here to the right is that after the tender was closed, on 19th of October 2023. After tender had completely closed, we reached out the petitioner to state that pursuant to your application. That email is at page 116. Pursuant to that, petitioner submitted the document, which is a part of the annex of the petition. Date of 1/29/2023. which might make a senior player had to pay it. But the relevant point in time before the matter was before the IUC for consideration, the petitioner had furnished a copy of detailing one
Then there. My question is whether that document which he has uploaded, or have you looked into the original document or not? You have not. So therefore, this is the case where you need to look into. And that is a rectifiable defect which has been held by many cases by this court also. Now, kindly see this particular clause. Where is that? Final processing, land level, field verification. B. Where is that? Yeah. Mr. Counsel, where is that clause? Rectified. Non-rectifiable. Group of land as declared by AI in the application, it is okay, non-rectifiable. Then the group of land as declared by AI in the application. Production. Now, you have found him. You have found him to be in the group 1. Okay. Then you go for verification. So you did not rely on that document. You went for verification. You are required to non-production of the original. You didn't ask for verification. No.
the documents that the petitioner also possesses in his possession, pursuant to which he is entitled.
So did you issue him the provisional intent? So therefore, once you issue the provisional intent, the next step is for FBC. Anyways, you had some problem. Why didn't you ask him? Ask him the original. When he produced the original, you should have seen the original and furnished it.
I filed this representation 139.
And where is that clause, Mr. Counsel?
My lord, 150.
In case the location involves a selection, there is a option.
155.
In case of rectified, they are not submitted within the stipulated time, or submitted rectified are not as per the required information regarding rejection of data they have to pay, sent to the provisional year. Now, what about this? Kindly see, this is important. Scrutiny of the documents would be carried out only after receipt of 10% of the security report. You gave that.
My lord.
In case of rectifiable deficiency in the document submitted, intimation to the provisional year to be submitted amid the required corrected documents within 21 days. Did you do this? Did you do this? Submission, that's what it takes. Submission does not. Okay, you make your submission, we allow you 1 minute at the cost of the public. 1 minute it will be at the cost of the public. What do you say, Mr. Bukalian? 1 minute, every minute at the cost of the public, make submission. Unnecessary. This is an unnecessary litigation. This will impose cost upon you. Won't cost upon you. Unnecessary litigation. You should have done it, looked into it and finished it off. This, you have not complied with number 10. Clause 10. E10. 14E10. You have not complied. And where is the original document? Mr. Counsel, again you are saying. What should I say? In what language should I say? When I'm asking, where is the original lease deed?
With the litigant, with the petition,
So that is, you should have taken a certified copy if you have not trusted.
I have, my lord, filed a representation. They have denied, my lord, any hearing, my lord. They have taken a hyper-technical.
This is to be, you got to stay.
My lord,
You got to stay.
only to the extent.
Interim order is there. Now, just for example, let me see here. Now, this is of 2023. Now, as of now, we are in 2026. 3 years have already gone by, no stay. So therefore, now if you want to give it again, it will have less than 19 years. How do you take care of it? My question is, you need a lease deed for 19 years. What do you take it? That is the basic formula. Either you are the owner or having a lease deed of 19 years, 11 months. Now, as of now, if you go and issue him also, that would not suffice having a 19 years, 11 months. How do you take care of that?
Guidelines, restrictions of page. That is 55.
Page 50.
Page 55. Page 55, my lord, list of non-rectifiable conditions. Number four. Point number four, my lord. The O. G and O. O is applicant would not produce certificates. Support of anything.
No, that won't come.
Before that, A, my lord, group of land, G, group of land as declared by the applicant, the application.
It's okay. He has declared it to be one. He still continues with one. So these are duly met. No problem. Good case. Very good case. You are entitled to postpone them. It out. You have been doing every time. No, there's no two lease deed. There's one lease deed. That is why. Do you think that the moment you said that, do you think that I have not looked into it properly? Kindly see. First, what I looked into. Before they made the submission also, you see, they finally come to page 126 and read it with page 117. This is the non-judicial stamp paper, which is having the same number. So therefore, the number is same. The document is one. It is only the question as to whether the page 3 is the document or the page 3 of annexure 9 is the document, or page 3 of annexure A1 is the document. So that is the issue which you should have sorted it out. But if you have said anything also, you are going to verify. Then verify it would not be good. Anyways, you produce the original. Today is what day? Tomorrow? Not possible. When?
Friday.
Friday not possible. Friday, there are so many lawyers are sitting. Do you see? Already I have spent so much of time. Okay, Friday. Monday at 2. Get it. List the matter on Monday at 2 for final disposal, as the petition have been duly heard. The learned counsel appearing on behalf of the petitioner is directed to produce the original of the lease deed dated 22/9/2023, which have been enclosed as annexure Roman 9 to the writ petition. In time orders passed earlier shall continue with the discussion. Yes, Mr. Baker.
The Joint Director of Health Services, District Health Society, Lakhimpur, my lord, has circulated and advertised tender notice, my lord, as per in response to the tender notice, my lord, the petitioner, along with other, have submitted their bites, my lord. Accordingly, my lord, on 21st of September 2023, the tender committee meeting was held and the final decision has been taken. Accordingly, my lord, on the same day, the notification has been circulated. Where, my lord, the petitioner was allotted 2 numbers of packages, my lord, that is number 2 and 6, my lord. That notice, my lord, I have annexed here, my lord. At page 30. At page, my lord, 29.
So there's a stage of renovation of some work.
Yes, my lord.
Yes, tell me, where's the impugned order?
Impugned order, my lord, at page 30. 5. This subsequent notification, my lord, without any knowledge, my lord, review has been made and accordingly this notice has been issued, my lord. Thereby package number 2 and 6 allotted to private
What is
response
the
number
name of the petition?
2, yeah, my lord.
You were earlier granted
Granted, my lord,
on 21/9,
on 21/9.
and then it has been granted to
Some
two
other-
persons.
Yes, my lord.
Why?
My lord, reason stated in that notification is only that this is to notify you all that all selected by the applicant are directed to.
Where?
Note, my lord, page 35, my lord. Note, as per directions of the district administration looking to the previous notice number so and so, that is so and so is hereby cancelled. All selected by the plan applicants are directed to report at office of the joint director, health services, district health society looking for. Then, my lord, petitioner was not able, subsequently when he has not received any communication as per decision of the meeting held on 21st of September, my
What is the
lord.
reason assigned, Mr. What is the reason assigned?
But after the opening of the financial bill, the deputy commissioner directed the joint director to conduct a review of the entire process of tender to the financial account officer of the health. Then he submitted a report, and based on that report, the review was made. And the L1 bid of the petitioner was not accepted and it was granted to the responsible. The package went. That is what there in the affidavit. On the last occasion, the honorable director furnished the report of the power. And sought for that matter,
Where you shown that?
yes, not will find it in the affidavit. That is entirely based on the report of the power. Page 19. Get up for it.
But tell me, page 91. Here we see the petitioner having been awarded on, the respondent was awarded on 11/12/2023. Initially, the petitioner was awarded on 21/9.
Not awarded, madam, but found.
He was offered. Yeah. Then thereafter, a decision was taken on 39 by the DIA to conduct a verification through the POW of the overall tendering work. Whether the report is requested after receipt of the process work, the question is to conduct a verification process of overall. Where is the verification work?
That matter was, I had supported.
So you have no urgency.
Well, not to be one more thing, madam. Tender process. It was quoted, madam, following, madam, whatever was there. At all, madam. Like. Because madam, not to be seen, madam, 2 decades out of 10, madam, that have already come to the.
No escalation.
My lord, no, my lord,
escalation.
no such instruction is I have received, my lord.
No, there is no escalation. There won't be an escalation, it will be as per the debt.
Yes, ma'am.
To do.
My lord.
Madam, not to be, next week, let me tell them, madam, then, court has not been, or at two, madam, then they.
My lord,
Or it's only that, report will suffice, madam, why?
Because here also, page 91, 92, and 93, there is no reason. You say the POW has said.
So that report will.
Well, understood. So the POW's report was most essential.
when I went to the affidavit, I already fought for it. But they say they come more time, my lord. I got the communication. Let me next week, my lord. I've already asked condition by this week or by Monday.
So, Mr. Peke, I record your submission that you are willing to do at that.
Yes, sir.
Urge Mr. Secretary, the legal counsel appearing on behalf of Mr. Bubu, the learned petitioner and the general, as well as the standing counsel of the NHA. Here's on behalf of the respondents. The petitioner hearing have said the notice dated 11/12/2023, whereby the respondent number 7 and 8 have been allotted package 2 and package 3 respectively, which was earlier offered to the petitioner by the notice dated 21/9/2023. This is a specific case of the petitioner, that the petitioner, there is no reason as to why there has been a change to allot the said work to the respondent number 7 and 8, which was originally offered to the petitioner. It is further taken note of that pursuant to the order, pursuant to the note of the petitioner, on coming to learn about the appeal notice dated 11/12/2023, approached this court by filing the present petition. And the learning coordinate bench of this court by an order dated 22/12/2023 passed interim direction to the effect that the respondent authority shall not proceed further in respect to package number 2 and 6, which were originally allotted to offer to the petitioner. It is very relevant to take note of that that an affidavit in opposition has been filed by the respondent number by the respondent number 2 and 4, wherein the stance taken is that pursuant to the offer which was made by notice dated 21/9/2023, the district commissioner Lokhimpur requested the joint director of health service Lokhimpur to conduct a verification through the finance and accounts officer of the overall tendering process. It is on the basis of the verification conducted by the finance and accounts officer that decision was taken to allot the works in respect to package number 2 and 6 to the respondent number 7 and 8 by the impugned notice dated 11/12/2023. However, a perusal of the said affidavit do not. However, to the said affidavit, the verification report on the basis of which such action was resorted, the impugned action was resorted to, have not been brought on the court. The legal standing counsel of the NHA submits that the same shall be produced on the next day. This court also inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner would like to further proceed with the package number 2 and 6, taking into account that the said notice, the said offer which was given to the petitioner on 21/9/2023 is based upon a tender dated 29/8/2023 and the rates which were submitted at that relevant point of time. The learned counsel appearing on behalf of the petitioner submits that the petitioner is willing to carry out the said work if allotted without any escalation. Taking into account the above, list this matter again on when They have done this. On 21st of May 2026 at 2 p.m. on which date Mr. Igogo, the learned standing counsel and his team shall produce the verification report. Advance copy of the state verification report be provided to Mr. M. Saikya. If they want a custody, shall continue. What is the what matter is this? What? On payment of bill. How much? Then? What about the performance security? You are asking. That also why not payment. And what is their stand in the affidavit? Yes, sir. Respect of performance, they say nothing like. All of it, I think, paragraph 6. So this will be paid as per subsidy. It will be equal to 440. And what about the performance security? Why are you not filing an affidavit to the effect? Why are you not filing a reply? As regards the performance security, if you are happy with this, you don't get this, then that amount has been different. The next sub A is 100. That in respect of contractual loan, that will be paid monthly. In respect of performance, they verify. And that will be my money, my performance. I have to tell you, penal. Then 9. If they want anything to be done, they can be done. And if nothing, that will be paid. And there are 9. They are not denied it. This outstanding bill amount for 40 lakhs, along with the significant amount 38,770. Deducted from Hassan. The petitioner herein has filed the instant petition, claiming an amount of 15 lakh, 3 crores, lakhs, 51,001, which includes an amount of 2 lakh crores, 40 lakhs, 35,401 as outstanding due, and the remaining amount pertains to security deposit as well as the performance security. This could have duly taken note of the affidavit which has been filed by the respondent number 2, 3, 4, 5, and 6, wherein the amount of 2 crores 40 lakhs 35,401 have been duly admitted. However, there is no mention as regards the security deposit as well as the performance security. In this regard, this court grants 3 weeks' time to the respondent numbers 2, 3, 4, 5, and 6 to bring on record the stand as regards the entitlement of the petitioner in respect to the security deposit as well as the performance security. This matter again on 24th of June 2026. In the meantime, the affidavit be filed by the state respondents on or before 19th of June 2026.
Make legal order. My lord, it's the penal damage charges matter.
My lord, there was no such observation made in regard.
It is pertaining to what?
My lord, it pertains to illegal imposition of the penal damage charges and terminal charge. I am not raising terminal charge, my lord. I am only here in respect to penal damage charges, my lord. The railway has imposed penal damage charges, my lord. My lord, damage charges is basically a penalty imposed by the railway authority.
Go there. Railway claims tribunal.
My lord, railway claims tribunal does not have jurisdiction to entertain matters in respect to penal damage charges or damage charges, my lord. My lord, there is a coordinate bench of our honorable high court. My lord, there is.
Last time I said, you said that you are going to put.
I will satisfy, my lord. I will satisfy, my lord. My lord, there is a coordinate bench judgment of
No,
our.
where is that? Last time exactly the same submission you made. When did Mr. Goel?
That same matter, my
The
lord.
same.
It is the same
I
matter.
wanted to dismiss. I said, kindly don't dismiss. I had the coordinate bench judgment, so I'll show you. I said, okay, if Mr. Rakhi wants to show that, I'll show you.
And there are various
And
other
in
angles
this
as well.
context, today the matter is, kindly see, per contra, Mr. Athi, so and so appearing, submitted, there are other coordinates who have helped, the court has the jurisdiction. However, he submits that he has not got the judgments today. Today also he has not got.
I have, my lord. I have, my lord. I'll come, my lord. There is a coordinate bench of our honorable high court judgment which is going against me, my lord, which is stating that penal damage charges matter was remanded to the railway claims tribunal, my lord. Lordship have already seen. That lordship has already seen that judgment, my lord. My lord, however, in that judgment,
That is how? MFA.
yeah, my lord, it was in respect to WPC, my lord. It was in respect to WPC. It's going against me, my lord. That
Then why did you make a submission to this?
my
He wanted to go there.
my lord,
Didn't that?
I'll please request.
Okay, anyway, we do.
I'll place that judgment, my lord.
Which one?
Guwahati High Court judgment, my lord.
Where? Why will the High Court say that penal demurrage charge is outside the railway jurisdiction? It's never heard of.
My lord,
Counsel, if that is said, then obviously this is to be referred to a larger bench. It cannot be.
my lord,
The law is very clear. I have seen it.
Then lordship, in financial amendment lordship, it's come under what everything was under the reflective.
it cannot override, my lord, the act, my lord. Act is the sacrosanct in nature, my lord. It will have overriding effect over. I'll satisfy, my lord. I'll satisfy, my lord. There are 2-3 provision which was never considered by the honorable high court, coordinate bench of our honorable high court, my lord.
Where is it mentioned in the judgment that the railway claims tribunal doesn't have the jurisdiction?
My lord, it is writ petition was entertained, my lord.
Ignorant. Those judges are very good judges, but unlike me, my question is, why should I entertain this type of matters?
My lord, I'll just satisfy.
We have plenty of also.
I'm referring to that judgment.
Respondent authorities have failed to show that the penal level have been demanded after wide publicity. This is the direct judgment of this court.
My lord, however, section 37 was never considered. My lord, may kindly look upon section 37. It's a Calcutta High Court judgment, my lord. A similar issue was raised before the
Go to
honorable.
Calcutta. Liputwar has the jurisdiction there.
My lord,
Go there.
kindly look upon
No,
section
no, go to
37.
Calcutta.
My lord,
Alipurduar jurisdiction is meaning here in some portion is there. So let you go to Calcutta.
my lords, may kindly look upon section
Mr.
30.
Rathi wants to go to Calcutta.
My lords, may kindly look upon section 37. My lord, there is an express
The
bar. My
railway
lord.
tribunal out here, let him go to Calcutta.
Here in this nearby.
My lord's facts of that case and my case is totally different. My lord, may grant me 2 minutes. My lord, I will satisfy my
No,
lord.
I'm not going to be satisfied because you have not produced that document.
My lord,
No.
may kindly look upon section 37, my lord.
For what?
Of the Railways Act, it is creating an express bar that the damage charges matter cannot be adjudicated by the Railway Claims Tribunal. My lord. 37, my lord. Of the Railways Act, 1989. Relying on the section 37,
Just within the thing in the factors to control the fixation is different. Fixation of demerger charges. Obviously, Railway Claims Tribunal cannot. It is within the jurisdiction of the Railway Board. As regards charging it or claiming an illegal, obviously it can.
my lord, relying upon the section 37, my lord, this Calcutta High Court judgment. My lord, in a similar situation, one of the issue of claimant preferred an original application before the RCT Kolkata bench, my lord. However, it was dismissed on the ground that the tribunal does not have jurisdiction. Later on, the appeal was
Fantastic.
preferred.
Go there, Calcutta. Calcutta.
My lords, may kindly look 13.
37 also take care by the 17th final amendment. That was also excluded. But the substitute judgment.
37 has not been considered. My lord, I have gone through the Satguru judgment.
Levying any other charge which is unreasonable. No, you can't complain against railway administration. Any complaint that the railway administration may be made to the tribunal and the tribunal shall hear and decide such object. That
My lords, the section, look upon also section 13, my lord. It is only in respect to compensation for loss.
we now in the case of court. These are things which not been looking. In the clear, there is a very good bench of delight. We dismiss it.
My lords, kindly look upon section 13, my lord. No, minus, my lord, section 211 and 214, my lord.
No.
Section 211, it's defining damage charge, my lord.
Mr. Counsel, I'm dismissing it. Go to the division bench.
My lord, there's
You
just
heard
one.
Mr. D. Rathi Tadalani, no, this matter should be put a full stop in the single bench. Single bench judges would not understand. Two judges are necessary for appreciating your arguments.
My lord, this
Mr.
one.
D. Rathi, no, sorry. Heard Mr. D. Rathi Tadalani counsel appearing on behalf of petitioner. Mr. K. Gugoi Tadalani counsel. This appears on behalf of the railway administration, on behalf of the respondent. The petitioner herein is aggrieved by the imposition of penal demurrage charges to the tune of rupees 14,26,856, which the petitioner had to pay. And further, terminal charges to the tune of rupees 1,06,688. It is the specific case of the petitioner that the said amount which have been charged upon the petitioner would not have been done so as per law. The petitioner therefore have sought for the refund of the said amounts appropriate directions for the refund of the said amounts which the petitioner were compelled to make payment. Mr. K. Gogoi, the learned CGC submits that this court may not like to entertain the instant writ petition, taking into account that the petitioner ought to have approached the Railway Claims Tribunal. Inasmuch as the issue which is being sought to be raised in the instant proceedings comes within the ambit of Section 36, small c of the Railways Act 1989. In that regard, the learned counsel have referred to the judgment of the coordinate bench in the case of MS Satguru Engineer and Allied Services Private Limited and another versus the Union of India and 4 other, reported in 2025 GAU-AS:1001. The counsel referred to submitted that the issue which is involved is clearly covered by the observations made by the learned coordinate bench in the case of in the said judgment, and more particularly at paragraph number 27, 28, 29, and 30. This court has duly perused the judgment passed by the learned coordinate bench in the case of MS Satguru Engineers and Allied Services Private Limited, Sutra. And taking into account that the said or judgment is passed by a coordinate bench, this court is bound by the observations made therein. This court has viewed the said judgment, and more particularly, paragraph number 27 to 30, which is reproduced here in below. Taking into account that the said judgment has been rendered by a coordinate bench, the judicial discipline demands that this court follows the said principle. More so, taking into account the said observations, or more so taking into account that the observations made by the learned coordinate bench appears to be in consonance to the provisions of the Railways Act 1989 as well as the Railway Claims Tribunal Act 1987. Considering the above, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Before parting with the record, this court observes that the dismissal of the instant writ petition shall not preclude the petitioner to approach the Railway Claims Tribunal if so advised.
Yes, the petitioner challenged the ability of the private respondent for the retail outlet of HPCL.
What? You are against party?
What has happened during the exchange?
Huh? IOCL is this side. You are HPCL. See?
I Ahmed, madam. Sir, I Ahmed, person number 6. He appears in this case, madam. Today morning, Brian to have died, so madam, he has just sent the bill to me, madam. So I have put the signature there, but I could not go to the public.
Okay, Mr. Commissioner appearing on behalf of the respondent number 6 submits that he is not prepared with the matter. You have urgency? No urgency.
There is no interim order.
Huh?
There is no interim order.
Interim order is there. You have no urgency. You have no urgency. Taking into account the above, list this matter. This court have duly taken note of that the proceedings are complete. Accordingly, this matter for final disposal on 18th of August 2026.
I will not add the meetings are complete. My lord, my client has instructed me that we might find a reply to the private respondents, the essential AI.
You have also filed, you joined
I have filed an additional-
against the affidavit in opposition to respond number 6.
That is against the private respondent. Again,
You want to file against who?
if instructed, I'll file. That's why that part will not be. Okay.
So there is no urgency. Well, Mr. P. Bharadwaj, the learned counsel appearing on, Mr. P. Bharadwaj, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file an affidavit in reply to the affidavit in opposition filed by the petition, HPCL. List the matter upon such affidavit in reply is filed by the petitioner. Now you have to file it, otherwise matter would never come. Mr. Bharadwaj, tell me what is your matter?
Now, your lordship can in fact close this matter because the principal contention which petitioner has pertaining to conversion has been addressed now. And I have received a copy of the order passed by the Excise Department, Commissioner of Excise, wherein my lord, my license was converted from an online, IMFL on license to.
So nothing you mean.
Nothing remains.
The कागज kan diyo. The grievance of the petitioner in the instant proceedings have already been redressed upon issuance of an order dated 23/2/2026 issued by the District Commissioner Golaghat, whereby the petitioners IMFL on license have been converted to IMFL off license. In that regard, the order dated 23/2/2026 have been placed before this court, which is kept on record and marked with the letter X. Taking into account the above, the petition therefore stands closed. Mr. Aibot Thakur appears for the Excise Department, and you? What business you have? Nothing. Any good for you. Mr. B. Chaudhary appears for the Finance and Taxation Department. Taxation also. Finance and Taxation.
34 also similar, my lord, we have been given our, my lord, grievances have been addressed, my lord. So another
No,
order
these are all
was.
same day, same order.
No, my lord, this is a different order, although my lord, issue is
No,
same.
no, 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 no. All these petitions filed on the same day.
Yes,
I passed the same order on 17th.
Yes,
That is why I'm saying.
yes, ma'am.
Mr. H. is having series of things that we have.
Who are now-
Commissioner, is it by Commissioner? But in Excise. Dated 13/2/2020. Our District Commissioner.
Right.
Pertaining to termination and blacklisting, my lord. Then however, during the course of the day, today I received some instruction from the client that they are not,
What happened? You have been?
they intend not to pursue the petition, ma'am. They intend not to pursue the petition. Some, I think, discussion with the respondents.
He's not going to?
He's not pursue the petition. The petitioner intends not to pursue the petition.
Why? Just now you sought for time for filing
No,
reply.
The responder had also come on record.
Then
Then something happened in the
during the day,
lunch hour. ma'am.
lunch hour, things change. Any instruction?
Why not I have a written instruction?
Mr. Deepak of the Lewis, counsel appearing on behalf of the petitioner submits that the petitioner is not inclined. You have been blacklisted, then also.
My lord, blacklist.
Then what to do? How do you take care of it?
And the client is aware of that also, my lord.
The petitioner is not
Maybe it will be
inclined
withdrawn.
to pursue with the instant proceeding. And in that regard, I issued a communication to the petitioner, to him. The said communication was placed before this court, which is kept on record and marked with the letter X. Mr. So-and-so appeared on behalf of the CBC. The learned CBC appears on behalf of the respondents. Taking into account the above, the petition stands closed. Interim order passed earlier than we did. The unnecessary matter. You mentioned I would have ended. Yes, Mr. Non-payment police. Police, no police. What is this matter?
Paid for an extension.
Successfully submitted bid against the ninety for construction of the room. What type of litigation is this? Mr. Kumar, what do you say?
So we have also received instructions in this regard that we have not linked to the poor performance on this part. Is within this 20%.
What is this? Sir, I'm not dismissed. No, litigation, how can it be? Even notice can be issued. If something happened, then it is a different question. Cancellation notice has been issued. You are directed to be present on so and so for final measurement over the, if anything is done measurable elsewhere. In case of your absence from the stipulated date and time, the measurement will be carried out for you. Cancellation notice. You sit around there, provision for the PPN, they have. Extension. The extension you are asking this court to do.
Here, left.
Are Mr. So-and-so, the counsel appearing on behalf of the petitioner. And we are appearing on behalf of the respondent authorities. The present petition has been filed by the petitioner. Seeking directions for setting aside and quashing the notice of the order dated 3/11/2025 and 11/11/2025. As well as further direction that the respondent should extend the work for a period of another 6 months. In addition to that, the petitioner have also sought for a direction that the said contract wherein the petitioner admittedly have failed to complete should not be retendered. This court had duly perused the materials on record. And from a perusal of the materials on record, it is seen that the petitioner was required to complete the work within 12 months from 26/2023, isn't it? The petitioner admittedly could not complete the work within the, say, 12 months. It is also seen that on 3/11/2025 and 11/11/2025, cancellation notices have been issued, which is more than 24 months from the date, which is more than 12 months after the date of completion. And then also the petitioner have not been able to do any work, complete the work. Mr. M. Ria, appearing on behalf of the respondent, submits that to the instructions of the respondents, to his instructions, the petitioner has only completed 22%. 28% of the work instruction. And in that regard, have placed the parawise comments, which is kept on record and marked with the letter X. This court, upon perusal of the materials on record as well as the orders which have been filed, orders which have been passed by the respondent authorities, are of the opinion that the petitioner have failed to make out any case on merits for this court to exercise the powers of judicial review. Considering the above, this court therefore dismisses the instant petition as it is meritless. The case will go to the level. Additional senior government advocate submits that he is awaiting instructions in the matter. List this matter again. On 19th of June 2026, Mr. King, the government, the respondent state is directed to provide the necessary instructions as to whether the petitioner is entitled to the said amount. And further, as to whether any part of this amount claimed by the petitioner have been paid in the meantime. That I am, what is your matter about?
Being the leasing this lease was cancelled.
Yes.
During my lease, the lease was cancelled on the ground that that subsequent to this, that is this one already had. The upper limit was not mentioned. But it is within 10% increase of the last 3 years settlement. But that was not considered, and my lease was cancelled. Subsequently, the CEO was directed to operate the market, and the sort of court was used to stay that order, and I am operating the market.
No, I don't understand. On 7/6/2025, the estimated amount has been given.
Yes.
Where the tender,
That is related an idea page 23,
huh?
page 23 meters.
23. We are with Kotiali,
Yes, Palisotro Melo.
Kotia to lease.
No. Serial number 4, Palisotro.
Palisotro,
It was government rate as
83 lakhs.
83 lakhs. Yeah,
Then-
there's a subsequent notice was issued. 1,26,000. There's 30 million.
The
The
average has been put at 1 crore 40.
yes, it is Malato
1 crore
1.8 lakhs. In the last 3 years, it will
1 crore 48 lakhs, 350.
and Malata 10% increase. There
Now you have put in how much?
54 million. 54 lakhs 1,001. And this honorable court that was challenged earlier proceeding. That was Malato set aside. Malato that petition was dismissed. Subsequently, they preferred Malata. That was also dismissed.
Which one?
That is Malata. I have addressed Malata.
Oh, my judgment.
Yes, ma'am. Yes,
It
14.
cannot be less than that. Okay. What did I say here?
Paragraph 14, is 47. 14, paragraph 14 is
Is this the same bucket?
yes, ma'am. Yes, ma'am.
There was a challenge made by the other side.
Yes.
That it was given as that. So now they realize and now they are cancelling it.
Yes.
Although, the fact,
In terms of clause 12, where it is between it is that a tender of very higher value than this. We have not been. We have. Lowest viable rate have been mentioned. What the lowest viable rate cannot be lower than the tender value of the market. It should have been the basic rental. Then
Then Malata paragraph 16, 17, and 18.
the children of the settlement also. So therefore they cancel. This is in violation to the order passed by the court.
And it is also Malata after violation of the court, that is Malata case 55, paragraph 8.
wrongly interpreted the law.
I think we should know this.
They the. After some petition,
But then also you are
Yes, sir.
you're running.
Yes, stay was there.
I'll advise madam to repeat again this kind of things.
If it was a different case also, I would have seen. But is it the same matter?
I was also surprised when I saw that. The very first day I have submitted, madam, I thought
The case, I think it's a transgression. You ask them to withdraw. Then I think, because otherwise, who's again? It's so big only, and because if I vote it after a few days, after the election, I think I will be showing that I know it and there is a stay and thereby having it after vacation. But we need to show up a very poor image of that officer. The officer should be involved. Ask the officer to withdraw this officer. Let him continue for this, because anyway, he has taken the money and now. It put the minimum value. Yes, it cannot be legal value. But it cannot, because once you fix that rate, the contract rate, you cannot go below, there's no quarrel with that. But can be obviously up that rate, you have the minimum. If you fix. Out Mr. D. A. time, the learned D. time, the learned counsel appearing on behalf of the petitioner, and Mr. S. Doctor, the learned standing counsel appearing on behalf of the. This court have perused the impugned order dated 11/2026 issued by the Special Secretary, the Government of Assam Panchayat and Rural Development Department, which did you read the impugned order? Yes.
That will have the next order also.
As well as the order dated 16/2026 issued by the Chief Executive Officer of the Nagaon Jilla Police. And the reasons assigned in the said order. The reasons assigned in the said order appears to be not only contrary to the order judgment and order passed by this court dated 10/11/2025 in WBC number 6324 of 2025, but also contrary to the judgment and order dated 10/21/2026 passed in with appeal number 378 of 2025. The question is also apparent, it also appear prime facie appears that the said orders, the said impugned orders appears to be in complete disregard, in willful disregard to the judgments passed by this court as above noted. List this matter again on 10th of June 2026. The counsel, Mr. S. Doctor, submits that he would obtain instructions in this regard. The interim order passed earlier shall continue till the disposal of the petition. I think you should withdraw.
Interim order.
We take action.
Interim order.
All right. What is this?
They are finally affidavit so far. But we weren't successful in the picking of a store query. Were issued a provisional letter of intent which was cancelled, which is why we approached this court on a writ petition. Interim orders were granted. During pendency of the writ petition, they proposed that it can be settled. Accordingly, I was made to sign an undertaking that I will withdraw the writ petition. Submissions were advanced before this court that an amicable settlement is going on. But thereafter, they again floated a retender in respect of the same stone query. So, which is why, in fact, first day we were granted interim protection on 13/23.
No, I think the forest department will to give some time. Yeah, otherwise they. Remember? So. Mr. Ibota, the County Council, the Forest Department submits that the affidavit in opposition on behalf of the Forest Department would be filed without fail on or before 12th of June 2026. Liberty given to the petitioner to submit reply on or before 17th of June 2012. On or before 22nd of June 2026. It's the matter of 24th of June 2026 in name order passed earlier shall continue in the right. Need to file affidavit.
If sometime we document that.
You file affidavit with the case of the transport and dispersal. Whether it has been approved by the SLC,
By the district level committee, and in between,
the district level committee would not do. Has it been approved by the SLC?
so one of the authorities to get the file. I was fighting RTI to find out the reason for being able to process further my claim. Then one recently, they have asked me to resubmit my document because they have displaced my files that was submitted and approved by the district level committee. I was again directed to resubmit the entire file. So I began resubmitted it recently in 24. Then in between 25, began filing RTI asking them the status of my the case which is pending. So I received an RTI. They have said that your matter is being processed. However, I have to come before the court because again another month have elapsed.
Need to understand why you need to file affidavit. First, there are many. First, transport subsidy is gone. Then comes trade subsidy. Trade subsidy has also gone. We are a question as regards those which were having prior to the 2015. These are claims prior to 2015. Therefore, you need to file an affidavit. Without filing an affidavit, what type of matter? No, particularly whether it's entitled, why you have not considered. These are aspects which needs to be taken. Because his claim is on the basis of some schemes. Once these are schemes out there, these are policy, and thereby he changing his. So therefore, I think you could. You are paying for union?
No, that one.
What? Union?
Is not party.
Union is not, but Mr. Council, how is it possible?
The scheme was for the Assam Transport Subsidy Scheme of 1991, Assam Industrial Fund. Under the
Huh?
1991
Under what?
Assam Industrial, that's why Assam Transport Policy of 19.
Show me that policy.
Policy, the scheme.
Where? So many years I've practiced out here.
At
These
page,
type of matters I've never heard of Assam Industrial Transport.
at page 52. This was my registration.
Mr. Council, that is why I'm saying, I've never heard of what you are saying. I tell you what, transport subsidy came in 1971. It has been further progressed and keeps on going on. Now, at that time in 1991, you had the Assam Industrial Policy, which was 1991 policy. On the basis thereof, those people were also being granted the transport subsidy. This is how you were getting it. And it was extended from time to time. Then you have the 97 policy. It was extended. Then in the 2007 policy, it has been extended. And in 2015, they came up with the freight subsidy policy. Then after that, it removed the freight subsidy. So this is transport subsidy under the 1971 scheme.
But
You have to make the Union of India party. Because this is not being given by them. See, at the end of the day, who is going to pay? Now you see, you have to understand where, yeah. There has to be not only a direct sale from them, they are not going to pay from their pocket.
Industrial trade laws.
You have to make the industry, Union of India, Ministry of Industry, Union of the Government of India, Ministry of Industry and Promotion. You have to make them apply. You have to make the Government of Assam, Ministry of Industry, Industries, Commerce and Public Enterprise. Then without that, how can we go ahead?
We'll file an application for taking it to.
Mr. Gogo, you should have help your colleague on this. It's not for me to show. Oh, that is why.
My plan was on there.
Otherwise, you would. Mr. H. Puragoy, the learned counsel appearing on behalf of the petitioner, submits that you would like to file an impeachment application. Mr. K. Gogoi, the learned counsel, who additional senior government advocate who appears on behalf of the state sponsors, and Mr. So-and-so, who appears on behalf of the net fee, submits that 4 weeks' time may be granted to them for filing their affidavits in opposition. List this matter again on 22nd of July 2026. Reply to affidavit in opposition be filed by the respondents on or before 15th of July 2026. It is further observed that in the circumstance, any application is filed by the petitioner for impeachment, irrespective of the order passed by this court fixing the matter on 22nd of July 2026, the registry shall list the matter along with such interlocutory application before the court. Right.
You need some time, otherwise there the arbitration clause is there. You can get remedies there. Page 103 was the distribution summons.
Like a engagement of the security deposit or to a mutual cancellation of the contract. So, the arbitration clause, that's why they will find this affidavit raising the mentality.
Rating will consider on a good day.
I love that.
Sir, boy, you look into all my judgments and you for producing you and another one is Mr. K.P. Patel. They produce it everywhere and thereby you are not giving me any leeway. Anyways, Mr. K. Goko in the learned CPC submits that the respondents would like to file an affidavit in opposition. I would like to file a preliminary affidavit questioning the maintainability of the petition. It is the opinion of this court that the respondents may file. It is the opinion that the respondents is granted the liberty to file an affidavit on merits by taking the point of maintainability of the petition and without prejudice may be filed an affidavit in opposition on merits without prejudice to the point maintainability of the petition on the basis of the existence of an arbitration. The said affidavit be filed on or before 17th of July 2026. This is the matter on 22nd of July, 24th of July. Yes, state an interim order. Yes. What is this matter about? What are your instructions? Yes, sir. Yeah, sir. You're filing an affidavit? No. When? Next time. It's the MOI appearing on behalf of the PWD. That means that the affidavit will be filed within 2 weeks. To establish this matter again on 29th of May 2026. The affidavit will be filed on or before 25th of May 2026. Interim order passed earlier shall continue till then. Yes, Mr. Vishwas.
Yes, Milord. Milord, I'm appealing through VC, Milord. Lordship will permit me. Milord, I'm appealing for the petitioner. Here, my dealership agreement, Milord, was terminated, Milord. So, Milord, notice was issued, Milord, and they were asked to get the response to this, Milord. So, Milord, 7th of April is the order, Milord.
So if it is terminated, why should we intervene?
My lord, we are saying, Milord, this is arbitrary because in the meeting, because after the show cause on 22nd of December last year, there was a meeting. Milord, we explained that the landowner is creating trouble. They were aware of it, Milord. There were earlier round of litigation also, twice, Milord, before this court for recitement. But they rejected my recitement application, saying that it doesn't fall under the recitement policy, Milord, because I wanted to shift to a different location because of the disturbance by the landowner, Milord. Now, Milord, they call me, issue a show cause, I appear, I undertake, they give me time also. Milord, 22nd of December is the meeting. Then I apply to the concerned police station and the DM office. In the finally, Milord, the order came on 17th of February. There is an order against the landowner not to disturb my possession. Prior to that, Milord, 30th of January, I write to them that I am investing this thing, I'm taking this steps, Milord, land filling and other things. And I need, these are the instruments, I want permission to install this. So they were aware of this situation, Milord. 17th of February, I get that order, Milord. I get my position should not be disturbed. On 20th of February, they issue this termination letter, Milord. So, Milord, they did not consider.
Take a termination notice.
Yes, Milord. That notice your lordship will find at page number 79.
Huh?
79. 79. Annexure 7, Milord. Lordship has the page 79.
You can show cause notice.
Yes, Milord. On 21st of February, 21st of November,
Then
2025.
after the show cause notice, what's that?
Milord, they called me for a meeting, page 83.
8, 9. Then there is a minutes of person in the hearing.
Yes, 83. Kindly
Why
have,
are you saying that there is a violation of principles of natural justice?
Milord, kindly have page 85 of this, the final conclusion.
No.
B. Kindly have.
It was awarded to so and so was signed by Goyal. What's with the operative since so and so. Are you running the dealership?
No, Milord, I am not running the dealership right now. I am in the process of renovating the entire land and installing new machines.
Does it take 14 years for you to do so?
My lord, 14 years, my lord, we have made applications for recitement because initially the problem was.
No, rather recite take 14 years.
No, my lord, they did not allow us to recite. So therefore,
This is a good order pass.
Therefore, they have.
If you want to take your machineries back, give them the machinery there.
My lord, kindly have page 85.
Then what is this thing doing out here? Kindly come to page 97. There is a petrol pump, the pump out there.
Yes, my lord. That is the
pump out there for the last 14 years, which is not performing. Not of it. For last 14 years. They say Go there before the Supreme Court, arbitration, whatever may be, you have an arbitration.
My lord,
Go for whatever may be, this court is not going to interfere with this.
my lord, kindly have, my lord, they have extended the time, my lord. My
What?
lord, they have extended the time. They have themselves, my lord, in the meeting, page 85, my lord, kindly have. Page 85.
But they have accepted.
They have extended the time. Kindly have page 85, my lord. B. This is the outcome of the meeting, my lord. Third line.
Understood. My question is, you have not been running for the last 14 years and you have not been able to settle your with that landowner. Then why would they give you?
My lord, if you lordship see, my lord,
We
the state.
understand, Mr. Because out here, we understand one thing very clearly. What happens is this. You normally, what happens? It is the owner who is being given the allotment, or it is being given the allotment to those persons who is having a clear title of 19 years, 11 months at least. Now, here is the case, your lesser or the lessee, whatever may be, you are fighting out here amongst yourself. You have not been able to run the area for the last 14 years.
My lord, this is a rural area.
The
This is not a.
You may go out there and ask that, okay, can we allow me in some other side? That is the different thing which they may consider. But otherwise, what is
My
there?
lord, that's precisely, my lord, they did not.
Why should this court entertain this type of dispute?
My lord, why, my lord,
What is there, Mr. Goyal?
may I respond, my lord? May I just respond, my lord?
No.
My lord,
Type of cases does not be.
my lord, kindly just give me but 2 minutes, my lord. I will just lordship, I will place the my lord. What happened, my lord? There is a dispute. There is admittedly a dispute, my lord. In their meeting, my lord, kindly have para 4, page number 83, my lord. They recorded that there is a dispute. We are aware of it. Earlier, there was a law and order problem. The concerned SHO has written to us, and later on, my lord, the landlord is creating trouble because para 4 clearly states, my lord.
Mr. Biswas, I understand everything.
Yes, my lord.
They duly accept that yes, you are having difficulties.
Yes,
But
yes,
the fact remains that it is for you
yes,
to
my lord.
clear those difficulties.
Exactly, my lord. So
So
they give.
therefore, if you are not being able to do for the last 14 years,
No,
what
my lord.
remains?
So therefore, my lord, last year they extend the time and tell me you
The
comply with
question is,
this.
this court is not sitting out here 2 to 6 to give you any extension or don't believe.
My lord,
You
they
have
have.
any
I'm
case
not.
out there, it's a case of
My lord,
termination. And
my
these
lord,
contracts are terminable.
my lord, they have given me extension. My lord, I'm saying they have given page 85. Kindly have 85. My lord, they
And
say.
in fact, your termination has not been stayed. What is being they don't want to pump also. No. There are 3 types of pumps. One is where the person, the bidder owner. One is where it is being owned by the company. And the third one is where there is a franchisee or something. This type of, what is this type of dealership?
Here the machinery is when the property.
So it was, you provided the machinery. This is the third type. And he was running it. Huh?
Hereby forms for again.
But you have not supplied oil out there for
They have not taken. They have not taken. They have not taken. It's what
So now once you cancel this, you will be floating a tender. I think you do it. Public is suffering. So there is no stake in the termination. Only what will happen, the machinery is then not been given in.
So that we want to set up the account up to us within the 10 days.
There was a. Okay. Anyway. You want to file reply? Want to file? The people the transfer is taken on behalf of the general corporate. Submits that the respondent would like to file an affidavit of petition. This is matter again on 5th of July, August 2026. Affidavit in opposition be filed on or before 27, 2026. petitioner will be at liberty to file reply.
My lord, in the meantime, the interim order may continue, my lord.
What interim order? The parties shall maintain her with regard to those machinery. Are you going to take those machinery? No. And what are you going to do with those machinery not being used for the last 14 years?
That's updated version.
Huh?
That's updated version.
How there those machines are not used? Mr. Vikas, tell me in
Yeah.
India,
Yes, my lord.
do you find now a petrol pump anywhere, even in the remote control, with a machine of this type?
My lord,
Unless which maybe the tank may be of use. Otherwise, you don't, this type of thing that with nowadays, with the petrol price rocketing out there, these are all on shits.
yes,
Even they give 94, 9 liters, 2.9.2735. They go
Yeah.
into this. And here you have the, which is all manual. Who is
yes.
going to use it?
Well,
Anyway, in time order past 30 years.
very well.
I passed the interim order.
Grateful, my lord, grateful.
Yes, what is it?
Okay, client, but we are not placed.
Sure. So and so the learning council is hearing on behalf of the commissioner. The instructor of the learning council will hear on behalf of the learning council. The petitioner will not pursue the preliminary petition. Accordingly, that view of the matter, the petition stands closed in 10 minutes.